Welcome to my world. Come on in and make yourselves at home. Welcome to my life. I know everything's gonna be all right. Welcome to my world. Oh, won't you come on in? Welcome to my life. It's known as the Tiger's Den. Greetings to all of my subscribers. I want to thank you for being with me for as long as you have, and the new subscribers that's coming on in. We want to say greetings and thank you for your time. This is from Toothless and the moderators. Welcome to the Tiger's Den. This is the voice of Cheryl, and I am Toothless Tiger, bringing you a true story. Greetings, Phyllis. Looks like it's you and I tonight. Anyone that's looking or listening from the bushes, from the trees, from the sand in Belize, the ocean, the cruise ship, the sky, wherever you may be, welcome to the Tiger's Den. Thank you, Phyllis, for waking me up, because we almost missed another show tonight. Sometimes it's hard coming to a show knowing you're talking to yourself and your sister, but you make content for the world. And sometimes it gets to be a bit much, so sometimes you just say, forget it. I'm just going to skip tonight. One of the things I do, though, when I bring content, I try to bring things that I believe are pertinent and things that people really ought to pay attention to. It's amazing how a month later, the world is catching up with things that I pointed out a month ago. And so it's validation that what I do is truly needed, and I will continue to do it no matter who shows up, because one day people will tune in and want to know, what did that lady say? Or let's see what she had to say, because it is very I should say apropos, very pertinent to the time, because here we are a month later. Judge Glanville is gone, but things are coming out that I peeped back in June, such as the second Ex-Parta meeting. That really blew my mind when it came out on yesterday, since they just started back going to trial. Hey, Asatar, good to see you. Yeah, it really blew my mind when it came out on yesterday that the state admitted yesterday, not a month ago, but yesterday, that there were 2 Ex-Parta meetings. And I brought that up over a month ago. And perhaps I don't have the catchy name phrases that get people to get hooked into what I'm trying to share and teach the public. What I try to teach them is the trickery that goes on in the legal system. But tonight, I'm not going to use any of the other people videos. I'll be using my own that I did a month ago. And just to show where I've been with this case. And like I said, it's a lot of people that do this case, and they do an excellent job. But a lot of the things that they cover to me is sensationalism, and they're certainly getting a lot of people listening and buying into what they're saying and supporting their channels. I don't always get that, but I have some real supporters that are here for me no matter what. And for that, I'm truly grateful. Because I come here to help uplift fallen humanity and to educate humanity, mainly the Asiatic people of the land, because we're the ones who are so far behind, and there's so much rhetoric that goes with our history. We don't know what to believe, when to believe. And so we have to start researching for ourselves, because we're not going to get answers that we seek from anyone but ourselves. And once several of us continue to research, perhaps we can communicate one with another and help spread the word. Because a lot of people don't really want to hear you when you start telling them how things really operate in this place that we call the United States of America. A lot of the platforms censor you when you talk about us as a people. And it's very hard to get people to understand that and get over the pipe dream of somebody one day is going to come and is going to help us get through this. Then we'll start doing things for ourselves, because nobody is going to do it for us. We're going to have to wake up, smell the coffee, and do it for ourselves. That's just the bottom line. And a lot of people say, well, but I don't know how. Nobody knew how before they knew how. You just do whatever you think that you should be doing. And we have this thing, I call it, your best friend. And it's called Google, where it's a lot of information out there that we can start researching. At least it'll give us a starting point. And then you can start going back to the libraries, buying books and researching and finding out on your own. But I want to play a clip for you guys that I did a month ago. And let me get it. First off, I'm going to have to cut my music, because all of my videos have music in them, so I don't want it overplaying each other. And this music that we hear is called Wish You Never Left. And I thought that's absolutely beautiful. It's very calming to me. But let me show you all a clip that I did a month ago. And I put it in one of my videos, perhaps two, I don't know. I can't find the exact video that I put it in. But I want y'all to see this. And hear it. Now, if you look right here, there's a clip. These are my clips. Could it be two ex-partes with the court? And this was clipped a month ago, and only 3 people saw it. 3 people.
And Your Honor, the state has a matter we need to take up ex parte with the
Okay.
And Your Honor, the state has a matter we need to take up ex parte with the
Okay.
And Your Honor, the state has a matter we need to take up ex parte with the court.
Okay.
And Your Honor, the state has a matter we need to take up ex parte with the court.
Okay.
I made that a month ago. When I heard her say that the state had a matter that they wanted to take up with the court ex parte. But I also go back to my video and we're going to listen to a lot of the video. Like I said, tonight, I won't be listening to anyone else's video. I'm going to be basically playing mine to just show where my mindset was over a month ago. And I don't know if I was right. I don't know if I was wrong. I could just tell you what things that I saw when things started unfolding. To me, everything started unfolding on that 6th of June. And that 6th was the day that Mr. Melnick sent an email to Mr. Steele. Actually, he addressed it, I think, to Miss Hilton or to Miss Love. But he also sent it to Mr. Steele and Mr. Short. And he sent it to them because they were defense attorneys. And he told the state that Kenneth Copeland was his client. And he wanted them to know that he plans on pleading the 5th on tomorrow, which was June 7th, the day that he was to testify for the state. So the state thought. Giving a little bit more history to that, it was a week before the 7th of June. So I guess that would start with May 31st, somewhere in that area. It was a Friday, where the state had started courting Mr. Copeland, trying to anyway get him to come and testify. Now, the state said they were never aware that he wanted to plead the 5th, but he states that he told them all the time he wanted to plead the 5th, and he wasn't going to testify because they didn't know what they were talking about. And they kept telling him, meaning Miss Hilton and whoever the investigator was that accompanied her to meet with him and talk, was saying that, you're going to be, you don't have to worry about any of this. We're not going to do anything to you. We're just going to ask you about this time period. And he's telling them, but you don't know what all I've done. And where you may not ask me these questions, the other side may ask me these questions. So that was on, from that Friday, let's say May 31st, up until that Thursday, when they received the email, Thursday evening, the 6th of June, that Mr. Copeland is actually going to take the 5th. So nobody can get me to believe, and I said this in my videos, that they didn't have a conversation or email or something to the judge to let him know that this person is now coming saying he's his attorney, and now saying that he's going to plead the 5th. So we're going to be there in the morning because we're going to give him use immunity so that we can compel him to testify, because without him, our case can't be built the way we want to build it. And apparently the judge agreed, because that Friday morning, June 7th, before court started, the prosecutors had secured, they said, the signature of the judge offering use immunity. So by the time Mr. Copeland came to court and his attorney, That's when they found out he had use immunity. They had no knowledge about the use immunity. They didn't have a conversation with him about the use immunity. And I've broken down use immunity as it relates to the other two, which is derivative and transitional. Or is it transactional? Transactional immunity, which is the one that give you the greatest protection. Derivative give you a good protection. Use give you only protection from the words you say out of your mouth on the stand. But if any other information come out from any other sources and the state pursue that independently, then you can be charged. And they say that he didn't quite understand it after they came up with, knowing that they had messed up. But we know that that's not true. I did several shorts showing, when you've effed up, the look that you have. Let's view one or two of my shorts that I've done before now. Let me see if these are my shorts here that comes up, or if they're just shorts, period. No, these are just shorts, period. I don't want that. I don't want that now. I don't know what that is and who that is. So let me get out of there. And let me go back here. And let me go. Okay, I know where I gotta go. I need to go to my videos. But these are just things that I kind of noticed a while back, and I kind of wanted to point out to different individuals so that they can see the system, how it really is. We not knowing a lot about law and history, we think that everything really, well, we know that it doesn't work right, and everybody reminds us that we're not perfect. So we know it doesn't work the way we think that it should work always. But I just made a lot of little shorts that kind of let you know that these people knew what they were doing. And let me find the face that you have when you know you messed up. Mm-mm-mm. Okay. I see a lot of my little stuff. I don't see the one I want. There it is. Let me look at something right quick. I can see it better from my telephone than I can from right there. And let me see if I can tell which one it is. But I was trying to, drop little clues because you can tell these people know that they're wrong. They pretend they don't know that what they're doing, but they know exactly what they're doing. And unfortunately, when you get caught up in the criminal injustice system, things have to go through the process. No matter how innocent you may be, you have to be inconvenienced in order for it to play out. And it has to play out. It's no such thing as, oh, we made a mistake and here you just gone and go home. No, it doesn't work like that. Unfortunately, you have to be, almost lose everything you have before you will get the justice that you deserve. So hold on one second. I done looked through so many of these little shorts and I'm not finding the one I want, so we're gonna have to keep moving. But it was okay, here it is. It all makes sense now. Let me see if I see it over here in my little short things. I don't know. I'm in my studio, but I don't see every last one of my shorts because it should be over here. And I don't see it. Okay. Oh, I know what I can do. Hold on a minute. Let me just send it to myself and pull it up that way. Okay. Yeah, I'm really on the discombobulated line because again, I almost slept through the hour to come on. And had it not been for Phyllis that was on my side, I wouldn't be here right now. I would be asleep. One moment. You know, I know y'all remember me saying I'm one of the most organized individuals. Everything is in total disarray, but that's how I function and operate. So please forgive me. But here it comes right here. And it's so small on the computer screen, so I hope it shows much bigger on the this is it right here. And I don't know if it's going to show big or not, because they look awfully small. And unfortunately, I don't know how it looked big. But I want you to hear what it says. In my opinion, I don't know if you all could see her facial expressions, the way they really looked. But in my opinion, the judge knew that she was about to tell him that Mr. Copeland wasn't going to act the way the state had wanted him to act. And I voiced that and made that into a little clip. And I got a lot of good views on it, and I was glad about that because my thing is just to get the word out. People need to see, in my opinion, this modern day lynching, because that's what it is. Modern day lynching, in my opinion. So, we saw that. Now, why is that important? That's important because they pretend, again, that all of this stuff just happened without explanation. So to me, the day before, the email that was received is what caused them to want to give the youth immunity. When Mr. Copeland and his attorney got to, the actual place, they had no idea that, it was going to be going down the way it went down. So they showed up. They were going to do the youth immunity. Well, no, he was going to do the fifth. And so they went through all of this, but we gave you immunity, so you have to testify now. You don't have to worry about anything happening to you. We've taken care of all of that, which was not true what they were telling him. They were telling half-truths. And 88 Love is very good at doing the half-truths. And Miss Hilton was the one who was working with him, so she adopted ADA's way with the half-truths. But they were actually lying. It was not half-truths. So then when you go from them saying those things and you get to him getting up there, taking the fifth, and things played out the way it played out, at the end of that day is when, according to the clip, she asked the judge for an ex parte meeting. And, it went over our heads. Well, it didn't go over my head, but it went over many heads that she wanted an ex parte meeting. It wasn't until Monday, the 10th, when they came into the courtroom, Mrs. Steele kind of inquired about why they were starting late, and it was kind of pushed off, but it was after the lunch hour that it became a real issue. After the lunch hour is when he told him that it has been brought to his attention that his client's civil rights had been violated according to the Constitution, and he gave them the constitutional amendments that were in violation, which in fact was actually the first, the fifth, the sixth, the eighth, and the 14th amendments to the Constitution. And then Judge Glanville, of course, got upset because he wouldn't tell him who told him. So back a month ago, I kind of talked about this because I knew that something had to happen from the time they sent that email to prompt them to give him use immunity. And they never negotiated for the immunity. And no one knows what motion was prepared to take before the judge. Because normally these things are negotiated. They're not just given willy-nilly. That just normally does not happen. And then as many things as they say that Mr. Copeland is guilty of, and he not be a co-indictee, makes everything very questionable when they claim he is the boogeyman, but he's not under the indictment. That's strange, and I'm happy for him and hope he doesn't have to go back through the judicial system, especially since he said that he has served his time and changed his life. Everybody deserves an opportunity to do different. And behavior would dictate whether he's different or not. His actions and reactions to different situations. But right now we're talking about how the prosecution have contrived and manipulated things, and things are so bad that I don't see how this trial can go on, honestly, for it to be fair and equitable for all of the defendants. And that's what you're supposed to get in law. Impartial jurists, which is the judge, or tribunal, which is the court, and you're supposed to get fair and equitable treatment. And you're supposed to get an opportunity to face your accusers and defend against what that person is accusing you of. Now, with that being said, as a defendant, your job is not necessarily to do anything but to show up and tell your accuser to prove whatever they're saying about you, because the person that's accusing you, they are the people that have to actually prove their case. And there was an issue on yesterday with case in chief, and unfortunately Miss Love has been a DA for I don't know how many years, but she acted like she didn't understand the definition of case in chief. And that's the person who's putting on their offense, or if the defense decide to put on a defense where they call in witnesses, because some defenses, once they hear what the state has, they'll rest their case because they see the state has nothing. And so they don't even play with the state. They'll just, say, nah, we rest our case. Hi, babe, how you doing? But now here you have Miss Love not even knowing the definition of case in chief. And trust me, this new judge that they have, we're all hoping for a mistrial with prejudice. But in the event that we're not going to get that, because some of the attorneys don't really want it, they really happy that they're actually winning the case, they believe, because the state hasn't proved anything. Well, watching the little I've been able to watch and stay awake for the last 2 days, she's putting her house in order, and she's running this courtroom like a courtroom, one that we're accustomed to hearing about. So it's really amazing, and it's really pathetic, but you can't help but laugh knowing the grief that these people gave to the defense when Judge Glanville was the actual presiding judge, and the difference in the way Love has to bow down and become an attorney that's under the authority of a court. It really, really, really make us, just as crazy as their boss, make us look bad. It looks like we don't even know what we're doing. So when we say the boule runs everything, and you get positions because you're Sarah or you're frat, this kind of stuff make it look exactly like that, because they look like they are so confused, and she can't even answer a question. I mean, just a direct answer to a question that should be yes or no. So that's kind of frightening. But what I wanted to go back to is the things that I pointed out a month ago that's now playing out today. And hopefully some of these things will be the things that will help these young men come home with a mistrial, with prejudice, because double jeopardy attaches to so many different things. And this judge seems to believe that she can get caught up, which she's good. I mean, she's real good. So we got to give her props. But it just looks so bad for these women, Asiatic women, to be up here looking so dumb. That's the kind of stuff that will stop a lot of women from pursuing their dreams of being lawyers, attorneys, and district attorneys. because it's before the world to see how crazy they look, unprepared, and seem like they have no real knowledge of the law. And then the case law that they've been quoting for different things has nothing to do with the issue at hand in their present cause. And, as the pro se litigant, I know better than that. And then they go get case law, and this is the district attorney's office who has access to every system there is. So they have access to Westlaw. They have access to LexisNexis. There is no way on earth that she should be quoting a case from 1978 if there is current case law for that same issue. Now, you can use a case from 1809 if that's the only case that sets the precedence. But this woman is getting cases back in 1978 when they had cases as early as 2023. Does that make sense for you to use a case? And then they don't necessarily know how to use cases. They do comprehend that the cases from the state is the cases that are, the state is bound by, because each state has its own constitution. And then cases from sistering or brothering states or the U.S. Supreme Court, those are cases just to show how this law has been applied in other jurisdictions. So they do understand that, but the ones that you can get from your state is the one that carry the most weight because it's in a line with your constitution and your statutes and codes. So I want to play some of this, and it was doing, the buffering, and it may do that now. Sometimes I can tell this buffering has to do with the VPN, and so trying to come on or trying to come off, so it does something to the Wi-Fi. But I just want to play some of this, and I'm reading the codes and the the duties of a judge. And again, this was done a month ago. What is this? Okay, wait a minute. I want to do this other case. Let me go in my history. This is the one I had first, because what I said was on this video, could the actions, here it is. And I know this is my video, but I want to put on my captions. So, and as you can see, this is do the actions Friday of Judge Glanville, ADA Love, and Hilton seem, and I put a question mark meaning questionable. And this was done a month ago. So let me see. Let's start here. Let me go back a little bit. I'm talking in the beginning, so I don't know exactly what I'm saying, but let me just go back a little bit so we can hear me start out. To give legal advice, and we can't represent other people unless we're licensed, because that's the way this country do things. They take your God-given talents, your skill, whatever it is you bring to the table, and they monetize it. And they monetize it by charging you licensing fees and making you become licensed. And that's kind of sad, but that's the way it is in this country. A lot of people call this country the land of the free and the home of the brave. I call it the land of the free and the home of the slave. And that's just my personal opinion. There are a lot of things here that they don't allow us to say on YouTube. Sometimes I get confused what we can and what we can't say, what would be considered free speech and what would be considered violations of policy and guidelines. And it all seems to be sometimes a form of censorship. But if you had your own business, I guess you would make up your own policies and procedures the way you would want them. So what you try to do and what I try to do is comply to the best of my ability. Sometimes I miss the mark, but for the most part, I try to comply. I'm a cusser and I love cussing, and they allow us to cuss. They really do. We can cuss and call each other all kind of ugly names, but you know, since they're trying to commercialize more, and since I want people to really hear what I'm saying, sometimes I'll use a cuss word or two, but not as often as I used to. And I cuss not for the lack of the vocabulary. It's just that coming from where I come from, my daddy cussed like a sailor, and I loved it. And I couldn't wait to get grown. So that's why I cuss. And I know when and how and to make it fit any conversation. I don't cuss and attack people because I'm not a fighter. And I didn't come here for that. I came here again to help uplift. Now, when you look at this story about Young Thug, when you look at, I'm going to have to talk about somebody that's dear to somebody that's dear to me. And not so much as the person, but their actions are dear. But when you look at Bonnie Willis, and I have to start with her because she's the DA, and her mission with all of these RICO cases. And it started back when she was an assistant DA, and she worked under, I believe his name was Paul Howard, and at one time they were not going to prosecute the teachers, and then at another they decided to. Looking at what happened between she and Nathan Wade, and listening to the different hearings, and especially the commissioner's hearings, and I've covered that. I would suggest that anybody, whenever you get some free time, just really go listen to those hearings, and to hear the millions of dollars that falls into the hands of the judiciary and the sheriff, which falls under the judiciary, the clerk, the county clerk, I would imagine that's who that is, and the superior judges and the solicitor generals, which handles their misdemeanors. So they call theirs different titles. But when you look at the money that falls in their hands, they have an item lined budget that they go to the commissioners for to get the money. But when they get the money, they say they are constitutional officers and they don't necessarily have to use the money for the purpose in which it was granted to them. So they have, I know the DA has like a $36 million budget, 36.6. And then when they had this time going through, when we had the virus come through, they got this big sum of money, $75,000, to be split between 4 individuals and in the judiciary. And so I don't know how they split that money, but they split that millions of dollars. And I just heard me say 75,000. It was actually 75 million. So I didn't catch that. And then Fonnie Willis received another $2 million for SA kits for past people who had been assaulted and they needed to test. Um, she gets state and federal grants and county money, plus the state also helps her budget. So we really don't have a real accounting, and this is true for all of our cities. So let's get this perfectly clear. I'm from Dallas, Texas, and we're not exempt from controversy. I'm only covering this because this is a big story in Atlanta right now. This is a place, too, that's Fulton County's predominantly ran by people, as most would call, of color. Asiatic individuals is what I would call them. But what type of individuals are they is what we need to really be asking ourselves. And that's why on my thumbnail, if you read it, I just wanted to know, could this be the faces of the culture of corruption that is spoke about in Fulton County? And I was looking at a board meeting the other day, and I'm going to do a video about it. I be having all these great ideas in my mind what I'm going to do, but my body tell me, no, you're not going to do all of that. And so I don't do it. And that's why I don't envy anybody for all the people that they have, all the money they receive. I would love to have people. I would love to receive donations more. But I'm happy with what I have because I'm going to give you all that I have, and that's what I give you. Out of the abundance of who I am is what I give you. And I don't have any more to give. I be tired. I be, just don't have it to give. So I give what I can and I give my own. And that's what I will continue to do. But yes, the ARPA funds, exactly. That was the money of the $75 million. That's true, Kelly. But it's so much more money that these people get that's unaccounted for, because they had the ARCA funds as well. And the ARCA was, they said, like the whale, ARCA, because it was so big, they just called it ARCA. But that ARPA is one too, or it was called something with a D. So it was, they were saying two different funds, but there are federal grants that these people get. And what it does for me, it just shows me how this system has been in place all along. Okay? But we've had an Asiatic man for the past 20 years doing the same type thing. So it just shows me it doesn't matter if you're a male or female, if you're considered in the legal statuses, black or white, no matter who you are, if you have absolute power, you will be corrupted. Because as we know, it's not just a saying. Absolute power corrupts. Absolutely. And that happens with human beings. Some of us are able to discipline ourselves, and we may fall off the beaten path, but we pull ourselves back. And you can see how corrupt it is just with the autonomy of individuals being their own bosses on YouTube, and the lengths they'll go through to destroy people that are coming up and doing as great as they're doing. They'll start destroying them by talking about their family, talking about their children, exposing where they live, other personal business. So, it's true of all human beings, and we can't get away from that. But going back to this story, I was looking and researching, and I found this little news clip that I'm going to share with you guys. Now, this stuff that happened between these young men of Young Thug, they were, they said 2014, 2015, and it, dates back before that because they were younger than that, before 2014. But most of the things that they're talking about, these guys were committing crimes, it looks like, on their own, but they all grew up in the same neighborhood. And so they all are friends. Young Thug was one who happened to have his talent take him before great men, and he was able to get out, so to speak. And when you get out doesn't necessarily mean that you move out. And, you could have a residence somewhere else but you know, your roots is always going to be with the people that you grew up with. And so he tried to maintain relationships with people who were not able to give up the street life. I say not able because I think one element is missing in all of this, and something that we should be seeing a lot of testimony on, and maybe we will on the defense side, not necessarily on the prosecutors, because of course they want a conviction. But the elements of drugs that these young men were using, and then the lack of education, where you're locking up the educators. So what can you do? I've already explained numerous of times about the school board, and their philosophy is to find you people exactly where you are and make sure that you stay happy in that state, a docile group of people. You know, we're called minority because that means we haven't reached the age of maturity, and it is looked upon by most of the world that we are not mature enough to handle our own affairs. And we show that every day because all we do is bicker back and forth with each other. And we refuse to come together and learn the policy and the procedures that run this country so that we can become better people and do what all other people do. But that's another story. But when you go back, this article here that I'm going to play is 6 years ago. It was like 2018 is what it says, I believe. 6 years ago, and when you look at the date, it's 2018. So when you go back to March 8th, 2018, there was a gang, and they said they have a hierarchy of gangs. And I want y'all to hear this story, and I'm here to tell you, I didn't hear YSL or If Gang, none of that mentioned. Now, I did hear one of the other gangs mentioned, but I want you all to hear what the sheriff at that time had to say. And I want y'all to see the community leaders that were here then, but we didn't notice Fonnie Willis going to them when she was seeking re-election. She went to the old ministers of the old Baptist church. She didn't go to these community activists who went to ministers as well to try to help reach some of these young people and bring them into some type of help. So, let me play that for you guys. I want to make sure that the music is not too loud when we play it. I think it's down enough. Now, I think this is very important because Adrian Love and Fonnie Willis, they made their campaigns on gang violence. They were going to get rid of the gang problem. The gangs were taking over. But I want y'all to hear now, both Adrian Love and Fonnie Willis ran for DA in the 2020 election. Period. Cycle. Okay? And both ran on gang violence. Now, you're going to hear, I don't hear anything about the gang that they're speaking of today that they have in court. And I want to know what happened to this gang and the other 144 gangs that have been, they said, noted in the county of Fulton and the city of Atlanta, so it would cover all of their suburbs as well. So here we go.
with gangs. They're a problem all over metro Atlanta.
Atlanta police tell us that there are nearly 150 gangs just in the city alone. And gangs are behind many of the crimes like carjackings and car break-ins. Fox 5's Morris Diggs joins us now live with a closer look at the #1 gang that's terrorizing Atlanta and a group who wants to do something about it. Morris?
Well, okay, so do you live or work in the city of Atlanta? Has your car window been busted by a thief looking for a weapon or for your phone? In my exclusive report, the Atlanta chief names the #1 gang her investigators say are responsible for the mayhem. It goes by the initials DFW. Police who attend community meetings from one end of town to the next will tell you the crime they're trying to slow down is organized by and large by gang activity.
If you have to ask the question, why should I get involved? If you don't get involved, this terror that we're witnessing is coming to a neighborhood near you.
Michael Langford, Derek Bozeman, and other community activists announced a program to get Atlanta area pastors involved in an effort to grab a youngster and turn that youngster away from a gang. And when you listen to Atlanta's top cop, you'll get a pretty good idea just how big a task that could be.
We have files on 145 different gangs in the city of Atlanta.
We've learned there is a gang hierarchy. The #1 outfit goes by DFW. What is that? It stands for down for whatever.
A couple of the founding members were Charlie and Isaac McDaniel. And I suspect that those names resonate with a couple of you. They were involved with and committed a murder.
The McDaniel brothers, when they were both teens, got locked up for some serious time as a result of a murder, killing a mature adult man after they learned he was about to alert authorities that he believed the pair was responsible for numerous car break-ins. Chief Shields says while the two co-founders are behind bars, DFW remains potent.
They primarily operate on the Joseph Boone corridor, and where they've really turned their attentions to in the last year, 8 months, is Zone 2 high-end cars. You see the corridor, they go up, you go in the parking garages, you commit a theft from auto, and you shoot back down to where their home base is. I believe that you can say fairly that a number of the armed robberies they're committing are tied to the guns they're getting out of the stolen vehicles.
Langford and Bozeman vowed to do whatever they can to help the APD chief.
We're here in partnership to make Chief Shields' job a little bit easier by cutting off the numbers that end up coming to her in the first place.
Back live now on Joe Boone Boulevard, a two-pronged approach, the chief tells me. The first one is if there's a teenager and there's a chance, she wants to try and get that teenager into community activities, whether that be Michael Langford and Derek Bozeman or Police Athletic League. For the adults, she says the main cog, 22 to 26-year-old, she says they've got to be hit hard with gang charges out of the Fulton County DA's office.
Okay, that is what the chief at the time decided. Thank you, Taya. That is what the chief at the time decided. And if you recall, Ms. Timpson said that DA Paul Howard had a program for gang preventions, and she came in under that program to work with the teenagers in the communities where there were gangs. But I've never heard them mention the DFW gang. I also have a young man who tried to lead the gang, and he was shot and all kind of things happened to him, but he survived, and he's yet out of the gang, and he was able to change his life. What he's doing today, I don't know. But I brought that up because I believe now this gives more credence to all of the rumors that go around that Young Thug was targeted because of his millionaire status. You know, for a woman to go after an ex-president, and I'm not saying whether he is guilty or not guilty, because from my investigations and the videos that I've shown, Atlanta did not certify at least 247,000 plus ballots. So I can't say, and that's going before the court. And as much as Fonnie Willis say that train is going to keep on moving, well, I think that's just the song, because the appeals court did an interlocutory appeal. They granted it, which means everything stops. It's like a stay when you file bankruptcy, or a stay that we're most familiar with hearing, stay with an execution, meaning that's not going to happen today. So we don't know when this is going to happen, when they're going to hear the case, when they're going to decide the case. But we do know this, is that nothing is going to happen in that area. Now, I've heard some people say they can't believe that Judge McAfee said that some things were going to still go forward. Well, I believe it because I looked at and shared in a video why they're going forward, because Mr. Harrison, Floyd, and Miss Cutie are questioning those ballots and the validity of them. And so he's allowing them to put together how it's going to be done. And that was the hearing that I shared the other day, that he's giving them until, I think they said the end of July or something, is when their experts would be available. Because the state, of course, is saying that that's going to take thousands of hours, totaling up to over $1 million, where this young man who's representing Mr. Harrison Floyd said, no, it's not going to take all of that. Their people are prepared and they're ready to come in. And so that's interesting, because he's going to rule on that, but he's giving them the go ahead to put it together, to put the motions together for him to rule on. So I really like Judge McAfee and the way that he appear to stand for something. Now, we know it's not all of nothing, so it can't be all bad and all good. And there has to be some good with the bad, and there's going to be bad with the good. So we just don't know what we're going to draw and the luck of the draw. Going to Young Thug, because we're going to look at this trial, most of it, on Friday. And so we want to go ahead and get time in. Giving you a little introduction. There's this person that they've been talking about throughout the entire trial. The state is saying like it is their number one witness, and he's going to really tie Young Thug into this to show why this RICO case should be a RICO case. And then they said that there are 3 elements that must be proven to tie it in to make it RICO. None of us have seen the RICO yet appear in this courtroom. Perhaps RICO will, I don't know. But with this witness, the state was so upset. I believe they knew what they were doing. I believe that the judge knew what they were doing. And I believe that they knew it before they did this charade. I heard Young Thug's father, and I don't know if his word is bond or not, but that's his son. I love the way he spoke of his son and the history with his son, and he told it just like a mother. He didn't have to guess and look up in the sky or the ceiling. He just spit out, my son's birthday is, my son is this, my son, and that touched me as a mother. So I'm just going to say that I don't know if any of this stuff is true. And he said that he has receipts for whatever he's purporting. And we'll see that sooner or later. But one of the things that we do know is Young Thug is not a convicted felon. He's been held in jail since his arrest 2 years ago. and he's been held without bond because they say he's this notorious kingpin leader of this notorious street gang, YSL. But all of the people that have committed the horrendous crimes, including their number one witness that they were banking on, has been walking around free. A lot of the gang members that they said that were gang members that has committed crimes autonomous from Jeffrey Williams, Young Thugs, all of that, they have actually let them walk free all of this time or gave them plea deals. So here you have Mr. Woody. And with Mr. Woody, they said that he was going to do this. He's done so much horrible stuff. He did things for the gang. He did this. Well, a year ago, an interview that he gave to two officers that are not known to be good officers. As a matter of fact, all of the officers pretty much that the state has brought as their witnesses have been caught in lies under oath, which is called perjury. Now, I don't know if they will suffer under the penalties of perjury, but they have been caught in making false statements under oath. Well, Woody says that he would say anything to get out of trouble and not go back to jail. Anything. And when he started his interview, he told them about his attorney, Mr. Melnick. And the police officer acknowledged Mr. Melnick was his attorney, but she didn't give him his Miranda rights that we heard, nor did she ask him if he wanted his attorney. They just talked that was his attorney and kept going for 3 hours. Well, the state contacted him last Friday saying, we want you to be in this trial, and let's go Friday before last, because last Friday is when all the kerfuffling took place. But on the week before that, they contacted him, and he said he had been telling them that he's going to plead the fifth. And the reason he's going to plead the fifth, I don't know if you guys remember, but I did a video showing y'all about Gaither and how dirty she was and how she didn't show up at that federal hearing. He went before the magistrate, but she didn't come back to the hearing to correct when the judge found that those two officers lied under oath. There was a question about who removed the weapon. So she never showed up, and they just kind of let that go. Well, the state is telling him that they would give him immunity. To me, that was a bully tactic, and it's almost like kidnapping, because most people that get immunity, they go seeking immunity. They're asking for it, and they either grant it or they don't. In this particular case, because he kept saying he was going to take the fifth, and they know the law, they used Georgia's code to offer him use immunity, meaning that they won't do anything to him for what he has to say, but he must testify. And they did that the morning of him supposedly appearing, and the judge signed off on it. Now, what nobody talked about was the fact that he did have a lawyer. And so they're going to make it sound like the state is that this man told them that wasn't their lawyer and all of this and all that. And they didn't ask him any of those questions under oath. And they're making these statements boldly, and they're making statements that's hearsay, and everything else would be speculation with any other situation. I'm making up this idea that somebody said that the state was going to hammer him, so he changed his mind, which all of that will come later. What we're about to see, I want y'all to just look at this for real. if you get a chance, if you can continue to look or listen. And I'd like for y'all to just, express your opinions inside the chat if you can. And Asatar said, yes, go Mavs. As a Lakers fan, I could never cheer for the Celtics. Okay, Asatar is kind of weird like that. He can never cheer for the Cowboys. So, go figure. But I'm a home team person, so I understand him going for his home team. I don't understand how he hates the Cowboys so much, but he can't stand the Cowboys. And this is Cowboy country. So here we go. We're going to start out with, now that they're calling him to the witness stand, and y'all going to hear that he had been down there 1 or 2 days, but this is very interesting. And I wish everybody in America would look at how this criminal injustice system is really working. And I really wished every Asiatic mother would look at this to see that, the sisterhood that we think we have or we would like to have, it's just not there. These women are heartless. It's as if they don't even have a feminine ounce in their body. I don't know what they act like, because we have honorable men, but it's just unbelievable. And to me, it all ties back to the monies that the DA office gets, the Superior Court judges get, and how they don't have to really give an account for those funds. And so we'll just take this thing as far as we can take it and funnel all the money we can funnel and do what we need to do. That's my opinion. Doesn't mean that's what they're doing, but it doesn't make for much sense to think any other way. Nothing about this case has seemed above board. Everyone calls it a circus and a clown show, except for the players on the prosecutor side. So let's hear as Miss Hilton, and I can't stand her condescending tone and how she tries to talk to these people. But let's hear her explain to the judge this before we get started. I'm using Fox 5 Atlanta's live coverage. I look at a lot of good people, but like I said, in viewing people now and listening to them, it's just safer this way for me, because I like their commentary and everything, but I don't know where people are in life, so I'm just going to keep it simple for me. And I want to thank Fox 5, and I want to thank the government for the Fair Use Act. And that's what we're going to do. Under fair use, we're going to watch most of this hearing. I'm going to be skipping around so we can hear the important parts. Here we go.
Yesterday evening, the state received a email from John Melnick with Mr. Steele and Mr. Sharp copied on that email. Mr. Melnick advised that he represents our next witness in this case. Prior to receiving that email, the state had spoken with our witness on multiple occasions in preparation for trial. After yesterday, at about 5 or 6 p.m., whatever time I received the email, he advised that we need to cease all communications with his client. However,
his client is
Mr. Kenneth Copeland.
okay.
However,
now to me, all of this was disingenuous, because she received that email, they had spoken with the judge while she's up telling him all of this, and he's pretending he didn't know. And nobody's really covering these type of things about the case. And the lawyers can't catch it all. And when you have a channel that a lot of people don't visit, and so they're just caught up in the whatever is going on today moment, you miss little things like this. But these are the kind of things that really helps to show why a mistrial should be granted, because he had already supposedly signed off on the use immunity when she's standing up there saying all of this based on that email that she had received the day before, which was the 6th. We're on the 7th here where she's doing all of this talking, and he's pretending not to have knowledge of any of this. These things are very important and play into what's going on now and him finally being recused from the case. Now, one thing the judge said today was that, she didn't necessarily use the term take issue with. She just cautioned on talking about a respected judge, and he is respected in his respect. But once you cross the line, then the respect is not the same. Now, the people that know him will show him the same love, care, and respect. But the people that are getting to know him are going to know him for his dishonor and not for him being respectful. So I think that too ought to be brought up. But, who am I and what do I know? I'm very verbose, and so maybe some of these things don't need to be said in the courtroom on the record. But I'm kind of also like Mr. Steele, where Judge Krause said that his motions are filled with hyperbole. I'm kind of like that too, because I want you to get the big picture. I want you to really see as close as you can to what I see. And I want you to know that even though you were not there, the way I tell this story, it's going to put you in the scene. So I understand how he writes. I appreciate his writing, and I really like his writing. Technical writing is good for those that are technical, and all judges should be. But as we can see how this chief district attorney, deputy district attorney, and chief justice, superior judge operate, they don't operate analytically. And so it's very important for you to be able to tell a story on the level of the listener, which the law adopts reasonable individuals, reasonable person. That's how you have to talk. Where, a kid, and I say child and not kid, but where a child can comprehend what you're saying. So let me get back to the story.
His client is not, there's no open pending litigation. We were operating as a witness. And so Mr. Melnick advised, I don't know if he wants to be present or not, but that he had court at 9 a.m. before Judge Krause. And so I'm bringing that to the court's attention. The state did offer Mr. Copeland use immunity in this case, so that anything that he testifies to in this particular proceeding will not ever be used against him. Your Honor has signed that order, and so we are ready to move forward. However, I did want to bring to the court's attention that Mr. Melnick did advise that he was his attorney and that he was present in the building. I believe wanted to either address the court, but
okay, well, if he's inserted himself in that particular respect, he needs to probably be here.
Now listen to the terminology that the judge is using. He said if he inserted himself. But if he's the man's attorney, how could he insert himself? They were trying to contravene and circumvent the law by going around him and speaking with his client, which is a no-no, according to the canons of, judicial conduct. So it's very, very, very strange that this man would make that statement, inserted himself. And we're going to hear that again, the insertion, because as I started this video off with, and for those of you that were not here from the beginning and showed you guys where a month ago, where these people are talking about now, the two Ex-Parte meetings, I said it a month ago is what I believed happened. Because I heard her when she said what she said. And then a lot of the things that came out of the transcript of the meeting on the 10th didn't make sense unless the people had a conversation before they got in the room. Because the things that they were saying were not brought up on the transcript. So how can you ask questions to an issue that you don't know the issue and then give answers to those questions that you never had a conversation about with an individual unless you've already had the conversation? So here we go. Let me just keep going.
So can we send somebody up to Judge Krause's to inquire? Because, or is he here? Is he outside?
I have not seen him yet. So
Is Mr. Copeland or his counsel present?
Mr. Copeland is present in the courthouse. Yes.
All right. Where's Mr.
Oh, maybe it's Carnes.
Okay. Can we see if we could find him, please, and have him tell him that we're about to call his client?
I'm not sure if any of Mr. Charlemagne still has. I do not have his phone number.
Okay. Well,
and while we're waiting for that, I do have two other issues.
hold on. Let me. Deputy Avila, can you ask one of your colleagues, or Deputy Ham, can you see if you can go up or have one of your colleagues go up to Judge Carnsdale's and see if we can, one, either get him down here, or two, ask Judge Carnsdale when he would be available. And tell him that we also have a witness that we need to call. Okay? All right, sir.
And then next, Your Honor, while we're waiting in that pendency, Mr. Copeland does have prior criminal convictions. The state did not see in any.
We might want to take those up if he's got counsel. Okay.
Okay. Well, I'll wait.
Yeah. So let's wait till his lawyer is actually here, so we can take up those issues if he does have counsel. Okay.
Yes, Your Honor.
All right. I'm just going to reset.
So the question becomes, if the judge is now cognizant that he has counsel, he wants me to believe that he did not know when he signed that use immunity that morning that the man had counsel, because it was because of the counsel on June the 6th that sending them the email stating his client is going to take the 5th, which prompted them to go to the judge June 7th before court started and get a use immunity signed. So that means they had to prepare whatever it is that they prepared from 6 that evening and have Fonnie Willis to sign off on it before 8 that morning, or 8 by 8 that morning, because the court started whenever it started, but they had already signed off on the use immunity that no one knew until that morning when they came for court that they had granted him this immunity. Everything about that sounds contrived and wrong, but they want us to believe. And the way they get us is because we don't study law and history together so that we can get our concepts right. They're banking on us being minorities, minor, incompetent, can't handle your own affairs. And so we accept a lot of things as being law, as being true, but actually it's volunteerism, which the 13th Amendment guarantees that you will not ever suffer from being a slave unless there are two things that happen: voluntary servitude are committing a criminal offense. Whereas many of us may not be convicted of criminal offenses, but what we are convicted of is ignorance, ignoring the fact that we don't know and not seeking that is written for us to know. It's written. We don't have to guess or take anybody's word for anything. We have to seek knowledge. And if we seek it, I guarantee you we'll find it. It may take 2 or 3 of us seeking it together and then coming together sharing what we found. But it can be done. We don't have the mindset to do that because remember, we received docility training for animals. So we've seen them work well together in a circus. And whatever the ringmaster or the person that works with them, their handler, say do, that's what the animal does. So we need to keep that in mind when we think of how our neighborhoods, our communities are so savage. It's savage because of the training we've had and then the hatred we've adopted for ourselves and each other. And we refuse to be like other civilized humans and put aside whatever it is we're going through for the sake of us all. Because the strength comes in numbers. One person really can make a difference. But why? When you have a whole nation of people who are in peril, in pain, in turmoil, everybody say we need something different, but nobody is putting forth the effort. And when I say nobody, please know I'm not talking about the people that are out here working every day, fighting for people that I couldn't fight for. Please know I'm not talking about those people. When I say all, there's not all of nothing. So when I refer to a group, I'm talking the majority. Most, not all. Because we know it's not all of nothing. I say the same thing over and over and over again because I'm just as repetitive as the Word of God. If you continue to read it, it becomes a part of you. And you don't no longer have to read it. You can recite it when you're speaking with someone. Why? Because it's in you. And what's in you is going to come out. But if you never feed your mind and your soul, which is your brain food, and your soul, which is the heart, if you never feed these things, and your gut, which determines your intuition, that's your warning signals, if you never feed those things, you'll never be able to function in this society as an analytical thinker, a critical thinker. Some people call yourselves free thinkers, independent thinker. Just thought I'd throw that in.
That's in place then. Sir?
Good morning. Can I just step out while we're recessing? Is that okay?
Yes, sir. Deputy Avila, can you ask one of your colleagues, or Deputy Ham, can you see if you can go up or have one of your colleagues go up to Judge Carnesales? Okay.
May I approach?
You may.
Good morning, Your Honor.
Good morning, sir.
So for the limited purpose of this issue regarding whether Mr. Copeland will testify at this trial, I am representing Mr. Copeland. Your Honor, I spoke with several individuals in the Fulton County District Attorney's Office before this case was indicted. And the Fulton DA's office was very well aware that I was representing Mr. Copeland. Apparently, they have had conversations with Mr. Copeland outside of my knowledge and presence. Now, I can't do anything about that because he talked to them without contacting me first. However, he did contact me yesterday and told me that he was being subpoenaed to testify here today. And I asked him what he wanted to do. His position had been and has always been that he wishes to exercise his Fifth Amendment privilege against self-incrimination. I have explained to him, and I learned this morning that apparently an immunity order has been entered under OCGA 245507, granting him use immunity for testimony at this trial.
Now, granted, he said he learned this morning. Now, to me, the judge is all the way in misconduct mode, because once they sent that email, he sent that email letting them know that he was his attorney. And Miss Love already knew, but she has no problem lying before the court. That's something that she does just like she breathes. And in the courtroom, they don't call it lying, they call it perjury, because it comes with the penalty. But in this case, it doesn't seem to matter. And that's another thing with us that I've learned from being, I call it pro se, but it's really sui juris. And that's when you go in your own person before the court. But one thing that I've learned in when you are going before the court, there's a lot of presumptions of law. And so a lot of things, if you don't seek and know what you're saying, then they're not going to tell you. And they will allow, because if you are a person with the right and don't claim the right, then you're no better than the person without the right. And nobody's going to tell you. You have to seek these things and be prepared and know what you're doing when you go. So the judge knew that this man was this man's attorney, but yet he went ahead and signed off on the use of immunity, which again, for me, in the job that I used to have, we were taught to follow the money. Once you follow the money, the corruption will be at the end, where they say it's a pot of gold. That's where the corruption lies. So if you follow what's going on and follow the money, then you can see what motivates them to blatantly do what they do. I learned, pro se, that two things normally don't enter a courtroom when you give your jurisdiction over to someone else to represent you before a tribunal. And that is the truth and the law. What I mean by that is, and remember, it's not all of nothing. So I'm not saying this is true of all attorneys and lawyers. That's not what I'm saying. But hear what I'm saying, the majority. If you notice in this case, if you follow this case, if you're listening to it on other people's stations and you hear certain things that they show, you will see that the law that this woman is, the case law, to back up the facts that she claimed that she's proving these guys' guilt, are not applicable to the situation. So it doesn't mean that they're not going to be speaking law, but because you have no knowledge of law and legalese, which is a special language created for the attorneys and the lawyers, and they go every year to conferences to learn semantics and how to use the words that called, you could call it wordplay. You say tomato, I say tomato. You say potato, I say patata. You know, it's just wordplay. And if you don't start playing with the words yourself, you're going to forever be in the condition that you're in. Now, one could say, well, you're in no greater position than me. Probably not physically, but mentally. And I call that with my brain and my emotions. I am. I wouldn't want to have to fight, but I was created to fight. So I'm prepared to fight. And if I'm not prepared, I'm going to get prepared. And I'm going to look up everything I can look up and ask all the questions I can think of until I get the answers that I seek. But most of us, we hear them talking this mumbo jumbo, and they calling out all these cases. Oh, let's say Toothless versus State, and 29D 4F 353. That sounds real professional, real legally, real lawfully. But that case may have something to do with dog walking. And we talking about me overeating at the all you can eat. So you have to really, really, really get involved in whatever it is you're going through, especially if you have the freedom to move around and do it. And although these guys don't have the freedom to move around, nor do they have the luxury that a prison offers, which is the state law library, if you can consider that a luxury. And it's not. That's not a luxury. But it is when you're fighting for your freedom and your right to be. So you got to be very careful, because these people will say anything. And if you don't know, it sounds like they're saying it in your favor, but it could be to your detriment.
Would object to that proposition. And the reason is this. I know very well that the district attorney's office knew about my involvement in this case from the inception of this case. I spoke with Don Geary in 2021 about this matter. And he asked me whether or not Mr. Copeland intended to cooperate with the state. And what he told me is that Mr. Copeland would probably either be a witness or potentially a defendant in this case. I spoke with Mr. Copeland. We had numerous conversations between myself, Don Geary, and Thomas Greiner, who's in the Fulton County District Attorney's Office, who was prosecuting Mr. Copeland for a separate matter. And Mr. Copeland has steadfastly said that he intends to exercise his Fifth Amendment privilege. I have also participated in a conference call regarding a bond for Mr. Copeland when he was when he had an indictment in Judge Whitaker's division. Present in that conference call was myself, Adrian Love, Adam Abadi, Abby Potter, and Judge Whitaker. And we very specifically discussed the state's concerns about Mr. Copeland getting a bond in that case, given that the state wanted to utilize him as a witness in this YSL case. So, Your Honor, Mr. Copeland is here. I can state as his attorney that he intends to exercise his Fifth Amendment privilege against self-incrimination. He does not wish to testify in this trial. And I would ask, there is no other, he's not on bond, he's not on probation, there's nothing like that. I would ask that he be allowed to leave this courtroom without being compelled to testify.
All right. Ms. Hilton, do you wish to respond?
Yes, Your Honor.
All right.
The notice, the court did not make, I believe, judicial notice of what he just asked, that he be able to leave the courtroom, nor did he note the objection that he objected to him getting this use immunity they're going to go on to explain about how only they can give the immunity and blah, 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 which has nothing to do with what this man is saying. And to me, I don't see how the court can even grant the immunity and him not spoken with the person and his client. I understand the state asked for it, but in, like I said, immunity situations, I've done the whole Georgia Immunities Act. And in immunity situations, which comes from the federal RICO Act, you're in negotiations and there are stipulations to the immunities that are given. And it's a process. It doesn't happen. I get an email at 6 p.m. Thursday, and at 8 a.m. or 8:30 or 9 a.m., the judge has signed off on the immunity, and then the person that I gave the immunity to don't find out until they show up at court. That's not the way immunity works. But nobody is talking about those things, the operation of it. Mr. Steele has brought those things up. But of course, one thing I learned in a court setting is you have to follow the process. So if you miss that step during the opportunity when it should have been done, that's why people object to everything that they feel is questionable, because then you can bring it up on appeal. But that means upon appeal, once a conviction is done, unless you have a situation like this where the stuff gets so crazy that you have to ask for an interlocutory appeal, and then of course a mandamus. But then there are procedures for you to be able to be granted those type of appeals, where it can happen in the middle of the trial, just like it happened in the other courtroom for Donald Trump and all of his co-defendants. So it's trickery at its best, but it's not like we can't learn it. We can even learn a foreign language if we put our mind to it. Most of us are so busy. As Silent Weapon says, keep the adults busy, busy, busy. Most of us are so busy that we don't make the time to do what we need to do. But we're at war because we're under occupation, whether we acknowledge it or not. We don't control anything. Everything is being controlled and handed spoon-fed to us. But we got to start at some point taking responsibility and accountability for the part that we're playing in this treatment that we're receiving, because we're playing a part, whether we acknowledge it or not. We're allowing a lot of this stuff to happen to us for ignorance sake, and that is ignoring what you don't know and seeking that truth.
And Mr. Melly, you are correct. I did go ahead and sign this morning. I'll make a part of the record the court's order giving him use immunity. Okay.
Good morning again, Your Honor. So first,
that okay, I could just slap him upside his head when he says that. Okay. Like he's really saying something. We don't want to hear her and what she has to say. We want to go. I want to play this part because I believe, I don't know this because I haven't spoken to Mr. Copeland and I don't know the operation of his mind, but I believe the way the judge explained this to him, that he did not comprehend when the judge says that you can tell them whatever you have to say. That even though he told him you can't plead the fifth, but after that he said you just need to tell them what you have to say. I believe, and he could have me wrong because I've been wrong before, that in his mind that meant he could say what he want to say so he could say he's going to plead the fifth. But I don't know that to be true. But that's just something that I believe, and I would like for some of the people that have him on their shows to ask him that question, which they probably can't ask him that question now because he's still a sworn witness. But maybe one day in the future we could get that answer. But here we go. I want you all to hear this interaction. Now, the judge is pretending like, he just found out about this stuff. But there's no way possible that he could just be finding out when he said to Mr. Melnick, I did go ahead and sign this morning, as if Mr. Melnick had knowledge that that was even offered to his client. He wasn't even included. So he's at a loss, and he's showing up basically saying that if you're not taking the fifth, then I'm going to have to get off your case, because he's done told them that he lies, he's a liar, he says just anything. And in all honesty, according to the rules of conduct, then an attorney or a lawyer can't knowingly assist you when you have knowingly told them what you've done, even though they've represented people that are absolutely guilty. They have done that, and they do it every day. But again, there is a process and there are rules. And as long as you play within the rules of the game, and the problem with us is the majority of us are playing the game, but we don't know the rules. So we come out losers every time. Says to this young man,
No, you don't need to be sworn in yet. No. All right, Mr. Copeland, your counsel, Mr. Melnick, have you had an opportunity to talk with him about testifying today?
Yes.
All right. Has the state provided you a letter of immunity or a copy of the order that I have signed directing that they give you use immunity?
Yes.
Do you have a copy of it?
Yes.
All right. Can we see that, please? I need 2 copies of it. Actually, 3.
You're fine.
Not yet, sir. Doesn't apply to you yet, Mr. Steele. But it is going to be part of the record, Mr. Steele. I haven't filed it yet under Odyssey. I don't think it's made the Odyssey system quite yet. So, anyways. Huh?
We have a proposal.
The judge is so rude to Mr. Steele, Mr. Shard, Mr. Matthews, Mr. Weinstein, Mr. Bott. It is unbelievable. The only one that he seemed to have a semblance of respect for is Mr. Harvey back in the back. He used to be a civil rights attorney, and he has a lot of big cases. They said that he's so good they even have a rule named after him. He's the only one that the judge seems to give any type of respect to. But he's very, very, very rude with Mr. Steele and Mr. Shard. And before I seen him be so rude to Mr. Matthews, I just knew he was very prejudiced because of the way he mistreat them. But he's very biased because they're interfering with the monies, in my opinion, that they're all abusing from all of these federal, state, and county grants. That's just my personal opinion. And I have a right to that opinion. And in Fonnie Willis's case, it's been proven there have been some odor of mendacity, lies, and proof of misappropriations of funds.
Order.
But I signed the order this morning, though.
I meant the manner in which it will be filed will not be made public.
Okay. All right.
Did you see the look that he gave her and what they were saying? And then she said, I meant, and we couldn't understand quite what she said. All of this is underhanded right before our eyes, but they say that they notice people interacting with body language and, well, let's say language other than verbal and audible language. These people are doing this right before the world. And he's always telling the defense after the prosecutor, Miss Love, have said some of the most stupidest, harshest stuff, that they need to remember their candor and they need to keep their professionalism, because after all, the world is watching, as if we don't see him and them becoming one.
Which copy's been given to Mr. Copeland? The order pursuant? All right. All right. Do we have extra copies of that? All right, Mr. Copeland, I'm going to mark this as the next court's exhibit in order, okay? Mr. Copeland, can you take a look at that order for me, please, sir? All right, let's just go through it right quick, okay? I just want to make sure that you understand where you are and you have your attorney here. And if you have questions of the court or your counsel, you can go ahead and do that, okay? All right? You have to answer yes or no, sir.
All right.
Okay, all right. I'm not trying to trick you. I'm not trying to do anything other than explain this to you.
The fact that he said, "I'm not trying to trick you," lets us know they were tricking him all along. And remember, this is why they said they had the ex-parte meeting for the 10th. Then they only came up with this to explain to him immunity because they felt he didn't quite understand. They also laughed and talked about his attorney not being present for him and going on a vacation, as if it's something wrong with a vacation that he had on the books since December of 2023. So that's why you have to be very careful. These people are trained in trickery, and they are trained on using every single thing that you say against you, no matter how innocent you say it or mean it. Because remember, truth is not the issue, although everybody relies on truth, they say. It's who tell the best story. That's what wins. Let me see what Bay said. I seen that she just made a comment. I thought he could say what he wanted also. They railroaded Woody and they are comfortable doing it. Yes. So you heard what I heard, because that's the way I interpreted it. But we'll play it again and see what others think maybe.
All right?
Okay.
Okay. All right. Mr. Copeland, this order reads basically, the state of Georgia has moved the court pursuant to this particular statute, which is 24-5-507, to compel your testimony. And our district attorney, Ms. Willis, having determined that your testimony is materially as necessary to the public interest. And that is, and if you take a look at the footnote, sir, I'm sure your attorney's probably explained this to you, that she has the purview of determining whether or not your testimony is needed for a particular trial. I don't even have that authority. Your attorney doesn't have that authority. You can't decide that maybe it's not really necessary. She makes that decision. So, and it's in the public interest. So, you've been subpoenaed in this case to appear before and give testimony in this particular matter, and state has provided the court sufficient reasons as to why you are necessary as a witness in this case. It appears that you've been properly subpoenaed to appear as a witness in this case, and that your testimony is necessary in the public interest. So that's how we, as a due process, gets you to come to court. I mean, you were noticed as a witness. They've identified you as a witness. They've determined that your testimony is needed.
Notice how he said that's how we, and caught himself and went with as a due process. He's practicing from the bench on the side of the state. And that's just the bottom line. You know, whoever loses the case has to pay big money. Big money. So just keep that in mind. I would ask you all to familiarize yourself with your state constitution, civil procedure for your state, criminal procedure for your state, and rules of evidence for your state, and then go look at the federal rules of civil procedure, criminal procedure, and rules of evidence. Most of the federal rules will coincide with your state numbers. No matter what state, they're going to be close in, facsimile. But just listen to this, y'all.
Because of the fact that you have some concerns about what your testimony may indicate or could indicate in this case, and that's something that you and your counsel have talked about, and I'm not certainly going to inquire about that. But in order to potentially deal with anything that may come out of that, the state is basically, knowing that you have a Fifth Amendment privilege, says, okay, we acknowledge that. We're going to give you immunity. And as a result of that, then you have to testify as a result of that. If you don't testify, then I, as the judge in this case, have several remedies. One of those is that I could hold you in contempt and jail you because the way that you get out of that contempt is to just testify. That's the only thing they wanted in this case, for you to testify. So your attorneys told me you're going to invoke your Fifth Amendment privilege.
If you notice, he didn't tell him the other remedies that he had up under his discretion. Wonder why. And then the Fifth Amendment right comes under the federal Constitution. That's part of our unalienable rights. Unalienable.
Done said. However, the immunity's been signed. I have a copy of that right now. So you're required to testify. So if you don't testify, the state's probably going to ask me to jail you. And I'm probably going to do that. So I'd like you to go ahead out and talk with your lawyer and tell me what you want to do at that point in time, okay?
Do you need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the Fifth.
Okay. You're taking the Fifth, but you've got immunity, but you still want to, are you going to testify? That's the thing.
That's the question.
That's the question on the floor. I've acknowledged the fact you have a Fifth Amendment privilege, but the state's giving you immunity, so that overrides that Fifth Amendment privilege. They require you to testify.
Yeah, but the state don't know what they're talking about. So they ask me a question that implicate me, then.
Okay, they can't prosecute you on that. They can't. The order prohibits them from allowing them to use that testimony against you. That's what your lawyer, and I'm not going to get into any of the machinations or intricacies of what may or may not have happened in this case, but Mr. Melnick is a very seasoned criminal defense attorney. I've seen him over the past 2 decades. I'm sure that he's probably given you very, very good advice, but the state can't use that testimony. They can't kind of say, have it both ways, like you testify and then you use that against you to indict you and prosecute you. Then we wouldn't have any faith that we need to have people come in and give testimony. So that's why they can't do that. They kind of can't go back on what they're going to tell you, So I signed the order. Now, they've asked for immunity. I've signed the order. So basically, whatever you have to tell us, you tell us.
Say no more.
Do you wish to testify, Mr. Copeland? Is that no? You have to say no on the record.
Say it again.
Do you wish to testify?
He said I tell him whatever I got to tell him.
That's
So I testify.
You will testify.
Yeah.
Now, I believe at that point in time, he believed that him saying he can tell him whatever he got to tell him was that he could tell him he's going to plead the fifth. Now, I don't know if that's what he thought or not. But the judge, to me, didn't make it right. And the judge didn't tell him the state is not going to prosecute you. But what he know in his head and why he was doing that smile was that the feds can. And he had already said to them he was not going to testify. He'd take the fifth. He shaved his head, and he's prepared to go to where he know he's going to go. Let's watch and see what happens.
All right, sir. Okay. What we're going to do in just a second is I'm going to go ahead and I'm going to call for our jurors. We'll formally administer the oath to you, and then the state will ask you some questions, okay? And then you'll be cross-examined at some point in time by potentially...
Can I speak to my attorney before? Because I think I just said the wrong thing.
Sure. I'll tell you what. Why don't you step outside and talk to Mr. Melnick? All right, can we summon Mr. Melnick and Mr. Copeland, please? Come on up, Mr. Copeland.
Some of the people said Judge Warris is the problem.
Come on up, Mr. Copeland.
Shaved his head, and he's prepared to go to where he know he's going to go.
Come on up, Mr. Copeland.
Say what?
I said, what's your pleasure, sir?
Crimes that occurred, crimes that were about to occur. He's at work, Bojangles, on Buford Highway, player. I don't recall. Anyone notice there are more guards in the courtroom? And these kids want to join gangs. Just speaking gibberish when she asks questions. That's still testimony. The state don't know what they talking about. Susie, when you don't understand something, you just fill in the blanks with fantasy and mind reading, right? So here we go. Let's hear this.
All right, sir. What's your pleasure?
Say what?
I said, what's your pleasure, sir? Do you wish to give testimony? I know you don't want to give testimony in this case, but you've been given immunity in this particular circumstance, use immunity. So, are you going to testify?
Yeah.
Okay. All right. All right, sir. Then what we'll do at this point in time is we'll call for our jurors and we'll swear you in. And
now this is what he's facing out in the free world, because everybody's calling him a snitch because of that tape that was leaked and all the stuff he was saying. But he said he would say anything to get out of there and not go back to jail. And he's been working with the police for years and years and years. And they know that. So that's nothing new. So they said he can't be charged for past crimes, only perjury. He can free the guys, bro. Get up there and spin like Bobby Miles. Someone said at Mookie, them guys got other charges. Being subpoenaed and having immunity, two different things. Cameraman. Rambo. I interned for a criminal defense attorney. What's your qualifications? Contempt. I don't know, COS. He got a subpoena for court. Woody don't have any charges. Judge about to take advantage of his power. That's what I say. You got to clear that up, because most people aren't that legal system savvy. The star-studded witness won't help the state, and they know that. That's why they won't call them. The Fifth Amendment don't matter. He has immunity. Ural pissed. Ural is the judge. What he mean the Fifth Amendment doesn't apply? Someone say he walked like a snitch. Someone say he better humble himself. Judge was a DA. And then they said he had a GUN charge. So let's go and see what happens when they get the jury.
we'll go ahead and take your testimony, okay?
All right.
All right. What is it, Mr. Steele? Does our witness need to be excused? Yeah, sir, go ahead and stand outside, please. If you wouldn't mind, we'll call you in just a minute. All right, Mr. Copeland has left us. Yes, sir, what's your pleasure?
Good morning, Your Honor. Good morning to everyone. Your Honor, I would like the court to weigh in on this, please. I would like it now, that's why I raised it, but if you do it on a break, that's fine. I mean, whatever you want. But I'm citing to court two cases, if you don't mind. Franklin, which is Franklin, like Donald Franklin Samuel, versus State, it's 166 Georgia Appeal 375. Yes, of course. 166 Georgia Appeal, 375. It's in Division 2, 1983. Also Waldrop, which is WALDRIP, versus Head, like Bubba Head, and that's 279 Georgia. 826, that's Division 2. It's Roman numeral 2A, capital A. 620 Southeast 2D2. Oh, that's wrong. 829 2005. And Your Honor, what I'd like you to do is the state has stated today, and Ms. Hilton told me this last evening. I don't remember the time, but maybe 6 o'clock, 7 o'clock, something like that. We had 2 telephone conversations. She said that she's met with Mr. Copeland and other members of the prosecution team. I asked for any notes that were entitled to exculpatory information under Brady. Ms. Hilton told me that there was one statement, and she emailed that to me and to everyone on the defense side. But Your Honor, I don't have any of the other notes. Mr. Copeland met with law enforcement on the January 11th of 2015. So God forbid the killing of Mr. Thomas is at 7:22 approximately, January 10th, 2015. By the early morning hours, I'm going to tell you about 4 in the morning, Mr. Copeland is on video, audio recording with Detective Thorpe the next morning. So it's January 11th, 2015. And he made statements that he knows nothing about anything. Since then, he has made additional at least 5 recorded statements that I'm aware of, and he's made other statements that I have nothing on. Anything, and he's been inconsistent. So anything that he told the state in this preparation would be inconsistent statements, which is impeachment evidence under Brady. And the state, I presume, will claim work product. That's why Ms. Hilton didn't give us any of the notes. But work product of the state is typically not subject to compelled discovery, except to the extent that such notes may be exculpatory and must be disclosed under Brady versus Maryland, which is 373 U.S. 83. Well, that's under Franklin, and Waldrop versus Head says that work product doctrine gives way to the accused constitutional right to exculpatory and impeaching evidence under Brady. So what I'm asking this honorable court to do is order the state to produce all notes. They had investigated. If they don't want to do that, I ask the court to get a copy of the notes in camera inspection and then meet with us ex parte so we can tell the court what we believe would be inconsistent statements, which is impeachment. That's why I brought it up to the court.
All right.
Your Honor, as I discussed with Mr. Steele last night, I turned over the statement that I believe was Brady, which was what Mr. Copeland told me about an incident in which there was a theft. And I provided that information to defense counsel. Outside of that, the state doesn't have any notes. And so there's nothing else to turn over except for what I did turn over. We do have one additional matter, Your Honor, which would be criminal convictions that I would like to address.
Okay, let's do. Let's deal with the issue first. The first issue of the notes. Okay. Do you have any written notes from your interviews of Mr. Copeland? What Mr. Steele is basically saying is that Mr. Copeland's given a few, he said 5 statements. And that some of those may be inconsistent, which would fall into the category of Brady, or may fall in the category of Brady. So do you have any written notes that you or your team took that arguably would be work product, but that I would need to review to determine whether or not they are on Brady.
We do not have any written notes, Your Honor.
All right, Mr. Steele, then that satisfies that issue in terms of that. If I find out that there's any other additional notes, then I'll change the terms of my consideration on that issue.
Your Honor, and I'll get you the case in a moment because I don't have it at my mind unless someone else does, but oral statements must be reduced to writing if they're Brady by the prosecutor.
Yeah. But I think they're saying to you that the only statement that they have that's Brady is the one statement they turned over already.
And Your Honor, furthermore, in addition to that, in our conversations with Mr. Copeland, he didn't give us any different information than what is contained in the 6 interviews that defense counsel has had since 2022. So there's, outside of this one sentence or this one piece of information which we gave, our conversations were not.
There's nothing. Are you telling me that there's nothing that that needs to be reduced to Brady?
Correct.
Produced as Brady.
If there was, we would have reduced it and sent it over.
All right. Okay. All right. Let's talk about prior convictions. Where's Mr. Melnick? Can you have him? Good. Okay.
Your Honor, and Mr. Sharkin showed, I believe.
Right in a few minutes. But I'm just going to try to rewind that just a little bit so y'all can hear that and tell me what you guys think after you see what happened. If you haven't already seen what happened, why do you think he stopped her from saying what she was about to say? Because we don't really know what she was about to say.
All right, ladies and gentlemen, please be seated. All right, thank you, Deputy Ham. They're introduced, so.
Everybody ready?
All right. Summon our jurors, please. Okay, all right.
John, just a reminder, issues with the closing. I don't know if the state played that today, but I just wanted to give you a heads up.
You're right, we're going to pass it on. I think we can deal with that after.
Okay, all right. She said you'll deal with it. She'll deal with them as they come, as they're introduced. So.
Everybody ready?
All right. Summon our jurors, please.
waiting on one, Your Honor.
All right, sir. All right, ladies and gentlemen, please be seated. All right, thank you, Deputy Ham. Ladies and gentlemen of the jury, good afternoon.
Good afternoon.
All right. Without further delay, we're going to go ahead and call the next witness. State.
Your Honor, Ms. Hilton calls Kenneth Copeland to the stand.
All right, summon Mr. Copeland, please.
Do y'all notice how she said that in her facial expressions and how she's looking as if she's utterly disgusted? You'll see why I asked that question in a moment.
Your Honor, here's that. Mr. Copeland is.
All right, I just. Here it comes. All right, Mr. Copeland, go ahead and approach the witness stand. Before you sit down, if you would turn and face Deputy Ham to be sworn as a witness.
You swear affirm the testimony to everybody get reported the truth, the whole truth, nothing but the truth, sir?
Yes.
Let me see if you state your first and last name with the spelling of both, please.
You say that again?
State your first and last name with the spelling of both, please.
Kenneth Copeland.
Mr. Copeland, do me a favor, pull your chair up as close as you can to the microphone and speak directly into it so we can all hear you. So if you could state and spell your first and last name for the record, please.
Kenneth Copeland.
Spell it, please.
KaennethCopeland.
Thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Brown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? From
All right, sir.
Mr. Copeland said he was grown, he was an adult, and he pleaded the fifth. Now, in my opinion, they all knew this because of the way she started out. Number one, I think I've heard her ask somebody did they want to be there, but she asked him, did he want to be there? Then she asked him will he allow her to ask him some questions? Then she asked, how old was he? That's not germane to this case at this point in time, in my opinion. So to me, she asked those questions because she knew he was going to plead the fifth. And they can't allow the jury to see a person plead the fifth with this type of immunity. So what she did was ask it over lunch, because I believe he thought when the judge said he got to say what he got to say, that meant that he could say that. Maybe that's not what he understood. I don't know the operations of his mind. But I know a lot of these young men were on a lot of drugs, and they did a lot of crime, and they don't have a lot of education. So their comprehension level is a little less than mine. And I don't have much, but I kind of understand a little bit about law, a little better than them. And so he might not have truly understood. You know, they asked us, do we understand? And we say yes, and a lot of times we really don't overstand, understand, or understand what's being asked of us or what's being said to us, because we don't no legalese. And we don't know that we may be saying something that we ought not say. But anyway, let's go on with how the judge is going to treat this situation and not against the state.
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody.
Now, we all saw the judge looking up all the different case law when they were talking about those cases before, they took the lunch break when they were talking about his prior crimes and things like that. What are the chances that the judge would have waiting for him on his computer what to say to him under what government code, because he was looking at the computer, if he were to take the Fifth? What are the chances of that? He knew once he got through looking up all those other cases just to put that on there just in case? Or did he have prior knowledge? The way he's going to respond, it would make you believe that he had prior knowledge. And the way he take ownership of what we didn't know as opposed to what the state didn't know makes you know that he had prior knowledge. It's amazing how this is going. And thank the two of you for still being here. Let's listen.
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony. Okay. What I'm going to do is I'll call our jury and tell them that you're going to be in recess for the weekend, and we'll come back on Monday.
Your Honor. The jury is excused. Would you please entertain a motion for a mistrial?
Mr. Steele, I'll entertain it right now.
I didn't want to hold the jury, but that'll be fine.
And what's the basis for your mistrial? We didn't know he was going to invoke. We didn't know what he was going to testify to, and I certainly didn't let him. He was only asked one question, so at this point in time, there's really, I mean, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case. Last thing we heard from Mr. Copeland was he was going to testify.
So everything you say, I'll adopt because I was about to say those words. Based upon information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information, but I was told that Mr. Copeland made that known to officers of the prosecution team prior to being called right now.
But it's what I was told. I mean, the last thing the court knew, and he has counsel.
If a party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, I mean, there's no doubt it prejudices Mr. Williams et al., all of them, because this trial's been going on now, I believe, 8 months in front of a jury, and they've heard Mr. Copeland's name however many times a court reporter says.
Casey, that's what we've heard.
No,
So,
the jurors have heard Kenneth Copeland.
and as well,
I
okay.
opened on him that he's a killer. We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his response was going to be, I'm invoking the Fifth Amendment, then, Your Honor, yes, I adopt what you said. That's wrong of a party, and I'm moving for mistrial. Okay. Okay.
All right, sir. Thank you. All right. Yes, sir. It would apply to everyone. Yes, Ms. Love.
Your Honor, I'd just like to put some things on the record
Sure.
regarding Mr. Copeland. As we stated earlier, Mr. Copeland has.
I don't want to interrupt you. Your Honor, I'm just telling the court I am not accepting the proffer.
Your Honor, if I may.
Okay, but counsel gets the proffer, Mr. Steele. I can accept that. So could you sit down? Is it time, sir?
Sit down.
Okay, thank you, sir. All right, Ms. Love, you can complete your proffer at this point.
Your Honor, yes. Just to relate to the court the observations that members of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for concern is Mr. Copeland's communication that he is going to us, that he is going to speak, that he is going to speak on the stand, that he is going to testify, and watching what happens when Mr. Copeland gets on the stand. Mr. Copeland did not want to have to be taken into custody.
Something just came to me, and you know, this is why this court is going to have to do she's going to have to do a mistrial with prejudice. I want y'all to listen to what Miss Love is saying. This is Friday the 7th, before they ended court. And I want y'all to hear what she's saying, because in a moment, I'm going to stop showing the videos and I'm going to read Mr. Weinstein's new motion, the supplemental, with the transcript from the Friday the 7th Ex-Parta conversation. If Miss Love just said all of this in open court, which she did, and then I'm going to read to y'all what supposedly was said in the Ex-Parta meeting on Friday, which is almost verbatim to what she's saying now. Houston, we have a problem, and a big one. What was the need to go back and repeat the exact same things that you're saying standing up there in open court to him in an ex parte situation, in the presumption that he doesn't understand his rights with his immunity deal, and he doesn't have the current or the present or the right representation. I mean, just think about this. They are playing so in our faces. They do this all the time. That's why they call us minority. And as I always state, if you get a Henry Campbell's Black's Law Dictionary 4th edition, which I give them away a PDF at no cost, all you have to do is request it through email. But if you look up the word minority, it does not mean in law what we assume that it means in everyday language. That's another legalese. See, one thing about legalese is they are mainly words that we use every day. But in law, they have a different definition. And then they speak to us in connotative linguistics as opposed to denotative linguistics. Now, a lot of these people looking at this group, you would think they don't know none of this stuff and they just as dumb as Dora. And perhaps they are, you know. And dumb as Dora is no particular Dora. That's just what people say, dumb Dora, where I live in Dallas, Texas. Growing up, when I grew up, that's what they say. It's not a particular individual that you're speaking to. But I just want y'all to hear what she's saying here, because when I read this Ex-Parte from the 7th, which, like I said, I believe they had, then something as Keith Sweat say, something just ain't right. It ain't right, y'all. Something ain't right.
The court gave him the opportunity to have present in court with him someone who is supposed to be representing his best interests. What we have seen is communication, both verbal and nonverbal, between Mr. Copeland's supposed counsel and counsel for defendants, and a look as if I tried from Mr. Copeland's supposed counsel in the direction of counsel for the defendants after Mr. Melnick attempted to assert for Mr. Copeland. May I finish?
Let her finish, Mr. Melnick. Please sit down. I'll let you start. Okay? All right. Thank you.
And look how he's treating Mr. Melnick like a wicked stepchild. And like he's not the attorney for Mr. Copeland. And this woman standing up there talking about what it looked like they doing. And they communicating with sign language and body language. And he shrugged his shoulders. And that man ain't shrugged nothing. Number one, he wasn't up there from our angle where we could see. Oh, I believe you can see it on film. She's not getting away with all of this. But I don't care how good Judge Whitaker is, and she seems to be good. Whatever you define good as. What I define good as is knowing this law. Because what we don't understand, law means one thing. It's the common law for real. And that is, if you don't harm me and I don't harm you, no harm is done. All of these statutes, acts, codes, all of this derive from the 1724 Christian Black codes. When I went on this journey 12 years ago to learn who we were before we were called slaves, I was such a staunch, devout Christian, and I wouldn't even contemplate going to some of the places in books that I have gone. I still have those same Christ values because that's what we have as a people, Asiatic African. But we've been labeled with war names. They're called war tags. And when you teach truth, on these platforms, they say you're giving misinformation. But everybody can talk about us as a people but us. We're the only group of people that entire identity was erased and stolen. Everybody has been enslaved, but nobody lost their identity, their culture, their food, their medicines, their language, their music. Nobody has, but the Asiatic African, which is the American Negro, is what they call us. But the attack is on the Asiatic nation globally. And if we don't start waking up and teaching our children, I can understand us as adults not wanting to change our belief system. I don't understand it, but I accept it. Let's say that. But if we don't leave our children with the knowledge that we, acquire while we're here, then our children are bound to be back where they say we once were, because nothing has changed. People are running around here talking about Project 25, Project 25. Don't you know you live in Project 24? You lived Project 23. You live Project 21, Project 22. And each year it's getting worse. And we are a group of people in time that's doing worse to our seed than has ever been done to us. People that passed on before us, our ancestors, didn't have all that we have. They had knowledge. So we can't say they didn't have the knowledge. Because way back when, they even had technology. Nothing is new under the sun. But we as a people got to get more serious. And I'm not mad at or angry at, but I do say things, the same thing a lot. I'm not envious of no one, but I really do care about what I do and what I say on this worldwide forum. I wish I had a tenth of the support that I see these people get financially, because it really breaks me every month to do what I do. But I'm going to keep doing it because this is my purpose. We all fall short of other people's expectations, sometimes even our own. When I see people just giving away hundreds on what I think is just sheer stupidity and humor, that's why I couldn't fault Kenneth Copeland for doing whatever he's doing to make money. He deserved to make money off of his story, just like all those other guys do, because everybody else is making money off their story. But it doesn't seem like anybody is really teaching us as a people how we need to really be looking at this and seeing the injustices that we've known that has gone on for time immemorial. Ever since we've known the system, it has been against us. I don't get it. And maybe it's not for me to get. And I guess my mind, I can't get on here and just say anything. Although I can as a human being, because we all can do it. But as a mother and a woman, a giver of life, and knowing how they subjugated us to get at our sons, knowing that our sons feel out of place because they don't have the opportunity to be the man that we created them to be. They have to succumb to the streets or the system. Some choose wisely, and it doesn't happen to them. And all we can say is yet. Because we know at any given time, we can't even call the police without us perhaps ending up unalived. So there is no help Imagine a world if we as a people did like these sisterhoods and brotherhoods and these AKAs and NAKNAs and ways and days and delta and sigma and all these alpha. Just imagine if we as a people started coming together in small sisterhoods and brotherhoods, teaching and sharing what we learn. Make it a point to learn something and share it. Most of us can't even talk to our close friends about what we've learned. They don't want to hear it. And we can't force anybody to hear it. But never stop dropping your knowledge, because you don't know the ears that may hear it, and it spark a flame in them, and they just catapult into whatever they were created to be. We can't stop. That's why I don't stop coming on here with 2 people, 4 people, 5. You know, I rarely get over 8 or 9 people at one time in my chat. But thank goodness when I go off, sometimes it's 50 people or 70 people that have viewed it. If it's nothing but for a moment, they'll know where to come back to when things get real harsh, because they're going to get worse. And it doesn't matter who sits in the jurisdiction of America, or I should say the United States, Washington, D.C. Doesn't matter who sits in that place. That has nothing to do with me. Anybody else can do what they want to do. But it has nothing to do with me. Yes, she did. I played the clip where I did that a month ago. I showed that a month ago. Okay. Okay. I don't know what she's asking me. Give me a moment, y'all. Okay, thank y'all for waiting. I was making a point. Now I don't know what point I was making. But I was trying to make a hell of a point. I guess when you do that and get off track. But I normally can come back to a point. So my mind operated a little different than most. It's kind of, I don't know what's wrong with my mind, but it's a little different than most. I can tell you that. It functions very strangely. Thank you. Okay. I think I was talking about support that people get. And you know, a lot of these people on here, they call it pocket watching. But I can see why we don't support each other in business, because these are businesses for us, but we don't support each other. And I see other people getting big cash apps and people flock to them to hear our story. We will not go to each other for our own story. We would rather hear it from somebody that does not look like us. And I'm not saying that they shouldn't tell the story, because they should, because we're all human. We are. But one thing I do know, we all have a different experience. A very different experience. And most don't even know what it feels like to have our experience. They can see the injustice, and that's one of the things I think is great about what's happening in Chicago, that the people are all ethnicities, because it's only one race, and that's the human race. That paradigm didn't come up with the legal statuses, That's a political status, black and white. It's not a human being. And we just refuse to learn truth as a people. We refuse to. And I can understand that because of a lot of the people that are teaching the truth. They also have these hidden agendas. And everything come with a price. But it is written that a workman is worthy of his hire. And if you're getting something for that knowledge, then it should not be a problem to compensate. And I guess that's why so many people give to the people that comes up with this buffoonery in their coverage and these tricky title names that really don't have anything to do with what's really going on, but it grabs your attention. And then people are like, they called us chattel. I call us cattle because we have the herd mentality. And so some people just follow people because this person's going, and I like that person. Or I'm afraid of that person. You know, like the person at work that everybody love to hate. Everybody hate the person, but everybody, when their birthday come, give them a gift. And then they give them the most expensive gifts because everybody's trying to outdo each other. But nobody really likes the person. But that person gets everything and really gives nothing but pain. You know how we try to teach our children about peer pressure, but we're at work succumbing to the same pressure, or we're online following people that are not worthy of our time. If they really knew us, they would be ashamed. It's amazing to me. And I'm not going to ever stop being me and talking about whatever I choose to talk about because I don't know no other way to be but me. And I envy no one because my mom taught me, don't envy anybody for what they have because you may not be willing to do what they're doing. That's why I can't get angry at the people that get all the donations and all the people. I'm not willing to come on 3 and 4 times a day or spend 24 hours a day online. I'm not willing to do that. So I can't begrudge anybody who's willing to do that. The only thing is, I wish in some of those times there was something that they would tell the people to learn. Like many don't understand the Constitution and the original 10 amendments. 7 articles, 10 amendments, which comprise of the human constitution. Our bodies have 7 functions. And that's, your organs, the systems in your body is 7. And then we have 10 feet and 10 fingers. Well, 10 toes, because we only have 2 feet. 10 toes and 10 fingers on 2 hands. 5 each. But that constitutes the Constitution, which the Constitution are actually jurisprudence principles, maxims of law that is in harmony with nature. That's the truth of the matter. And most of us don't know that. We don't know that the Constitution doesn't stand alone. Yes, it's the Article of Incorporations. It's their articles, but you have treaties. And the Constitution, along with treaties, are the supreme law of the land. Most of us, the only thing we know about treaties is something we saw in a movie, Cowboys and Indians. But it's real. And we need to teach it to our babies. A lot of us didn't learn this, so we can't get angry at ourselves for not knowing. What we ought to do is get angry at ourselves for not trying to find out the truth. One moment. Okay, I'm back. Yeah, so it's so much that we have to learn, but we just need to start with the little simple stuff. We're not going to learn all of the metaphysics and things from ancient Egypta and Egypt and Kemet. And we're not going to learn all of that, unless that's an avenue that you choose to take. But the basic fundamentals in order how to operate and function in this place today, we need to learn those things and teach them to our babies. It's a must. But let's finish hearing this, and then I'm going to read, and then I'm going to get off of here.
Sure.
While Mr. Copeland is on the stand stating that he wants to testify, that he will testify rather. So we are watching, and Mr. Melnick, I believe it may even be captured on film. The court can look at it. Mr. Melnick turns to the direction of counsel for the defendants and motions like, that's it.
So why didn't she object at that time? And why didn't the judge see it? And why didn't everybody else see it? I want y'all to know infamous Sylvia showed a video from her camera that showed the whole time that Mr. Melnick was in the courtroom. And you would never see him and the defense attorneys looking at each other, talking to one another. And I certainly didn't see him stand up there and shrug his shoulders like I tried. I'd never seen any of that. He came there telling them they spoke with his client without contacting him. Then they came up that morning and got that immunity deal so that they could make him testify after subpoenaing him twice. And now she's up there lying, and the judge is just going along with this. Everything else is hearsay, speculation, conjecture, but he's taking this as if this woman is telling the honest to God truth. And so let's just keep going because it's going to get a little rough.
Then, upon information and belief, as we are standing out waiting for the jury to come in, Mr. Copeland requests to speak with counsel for the state, but Mr. Melnick keeps walking in. Then, as
Does he at any point in time tell you I'm not going to testify? I'm invoke the Fifth Amendment.
No. As what happens, as Mr. Copeland requested to speak with the state, Mr. Melnick keeps going in, regardless of Mr. Copeland's request to speak with the state. And then we learn that Mr. Melnick tells Mr. Copeland they are going to hammer you. So Ms. Hilton comes back in and asks me, had I spoken with Mr. Melnick? Had I told him that we are going to hammer Mr. Copeland? The state had not made any such communication with anybody. So what we are seeing, we believe, is tampering with witnesses. This particular witness on the part of...
She's not saying they're tampering with witnesses. She's saying that his own attorney is tampering with a witness. But I want to just read this. It says, Woody has effectively gotten over on the prosecution. Someone said, oh man, he said, I am here, ain't I? You can't make it up. Shaking my head. Where the proof of all the stuff she's saying I'm going to add? Gutter snipe trash. Defense taking L after L. The DA intimidated the witness, and they knew that he was going to plead the fifth. This prosecutorial team is not playing by the rule of law. They are making up rules of their own. And that is true as they go. And it is unbelievable. Done deal. Smart move by DA. Judge is going to let Woody sit in jail over the weekend. That is so funny. Well, they said over lunch that Woody went on Instagram, and some people have it. They have a Snapchat picture of his Instagram post where he told everybody he was about to go to jail. He was ready to go to jail. He know he's going to jail. But he's going to jail now knowing that he's going to be all right, rather than going to jail under the manner in which they want him to go, knowing he could be in not only federal custody, but something could possibly happen to him. He is the one who has to live with his decisions. She can't compel him, as she thought, to testify, and he thought he was testifying according to what the judge told him he could say. And this is where he ended up. So here we go.
People who are not the state. So we are concerned. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with on breaks, and after Mr. Copeland has communicated to this court, he will testify. So why?
Now, when the crooked officer Gaither was there, she said, and I say crooked because she was proven to have lied. I saw that in the videos. I played it myself. She hasn't been arraigned for it. She hasn't been charged by any law, but that's just my personal opinion of her. And I can prove the lies that she told because I have them on video. But when she said that she talked to them every day and every day throughout lunch and everything, nothing was said. But now she had to purposely put on the record that who he's talking to during lunch. Now remember, this man just found out about what they were doing to his client the day before, Thursday evening. And then they ran after he sent them that email. So you know that they're disingenuous because they didn't offer him immunity until his attorney contacted them and told them that y'all know you all are wrong for talking to my client without contacting me. But let's keep hearing what she has to say. They think that dogma really works. That angry black female, as they love to call them. It doesn't work.
Watching the goings on as Mr. Copeland is not on the stand, it has been publicized, it has been hyped up that Mr. Copeland is the next witness. Mr. Copeland is the witness. And then Mr. Copeland, he's been nothing but cordial. He's been nothing but communicative with Ms. Hilton during the time that she has been interviewing him and speaking with him. And the reason Ms. Hilton was not in here just now when the jury came out is that Mr. Copeland asked to speak with Ms. Hilton. And the reason that we have a problem with this is that Mr. Copeland is not facing any charges. For Mr. Melnick to suggest or say to him that we're going to hammer him, it causes us.
She said he asked to speak to Miss Hilton, but Mr. Melnick kept going back in there and going back in there as if he wasn't supposed to be in there with his client. That lady sounds utterly ridiculous. And this judge is actually sitting up there just listening to her as if she's making some type of sense. I seen where someone said, love is just mad. Their case is falling apart. And then someone said that she knows that she's been caught lying. Everybody's telling her to take that G girl and sit down. Witness tampering. And what's so bad about it, she said there in open court that they heard somebody said that they were going to hammer them. But in the transcript of the other ex parte on the 10th, she said she heard. And this Judge Whitaker cannot look at this video. And I'm not talking about mine. I'm talking about the one that I got it from, Law and Crime, on day 87. She cannot look at this video and not know that these people are lying. And Judge Krause, even though she doesn't want to speak to anyone's character and honorability, that this is wrong. If you read the Supreme Court, the Constitution, they took away the nobility clause. It was taken out. So there is no titles of nobility. Matter of fact, it tells you you won't have any. So, I mean, we got to do better as a people, y'all. That's all I got to say. She knew. And she did know. She's not going to ever make me believe she didn't. The way she announced him and the way she looked. And when she looked when he walked by. Utter disgust. And then she told the judge that they said they was going to hammer him. Who said that? But he wouldn't let Mr. Steele call the people who heard him say out in the hall that he was not going to testify. Someone said Woody won't be tricked. No, they was trying to hammer Copeland. That's what they were doing before lunch. Yeah, thinking he wouldn't have to testify. Expose it, Miss Love. I knew the defense was tampering. That person sound crazy as all New York. Going to jail is some smart move. Get a life. Witness tampering. Backfired on the defense aides, they say. I don't think that backfired at all. They big mad and now she reaching. The man did what's best for him. He's the one facing federal charges. The defense is not facing federal charges. They're facing state charges based on a false premise of RICO. This man actually has some federal charges that he could get picked up. And remember, he had some federal issues that he didn't go to jail and prison on. So y'all gotta know. This is crazy. I'm going to read a couple more. And like I said, when I said he has federal charges that he can get picked up on, and I kept saying he has federal charges, he's not under a charge. And then I think I've heard him say in an interview that there's possibility he could be. I don't know any of that. What I'm talking about is some of the actions that he speak to when he has to testify may give rise to a federal charge. But one of the things that they kept saying to the judge, he is clear, he's not on probation, he doesn't have any charges right now, as if they can talk to him without an attorney, knowing that he has an attorney. That's where the issue is. They knew he had an attorney. And even if he didn't tell them, it was their duty as people of valor to contact the lawyer to see if he was still his attorney. That's their responsibility. You're responsible for your actions, not the action or the inaction of someone else. Then we're going to get back to the video. Okay, well, it's on his social media that he wasn't going to testify. Yeah, they said it was deleted, but he did put it on there. Earl is wrong. Let love talk down on lawyers. And then when he does correct supposedly her, he's always putting it on y'all all as a collective, as if other lawyers are doing that to her. Why she didn't say before Woody came in? I believe she tried to and the judge stopped her. But here we go. Let me get on mute so y'all can hear this because this is interesting.
us to call into question whose interests he's representing. And so we would ask that, you know, what I haven't even thought of in my mind an appropriate remedy at this point, because it is wrong for parties to inject themselves on behalf of purportedly one person, and I don't know. I guess they're, you know, I don't know what's going on, but I can say that this entire day, starting from the point at which Mr. Melnick is invoking Mr. Copeland's Fifth Amendment right after Mr. Copeland has said he's going to testify, has gone a little off rails, and it's a little bit concerning. So, Your Honor, as to this motion for a mistrial, we would argue that it's caused by actions on the part of people other than the state, that Mr. Copeland got here and said what he did. So we will continue to speak with Mr. Copeland, because Mr. Copeland doesn't have any charges that are open. If he asks to speak with us, which he has, we'll go and speak with him. That, and I'm not even certain what is going on behind me with respect to persons who are purporting to represent the best interests of Mr. Copeland. But it would appear to me that Mr. Copeland's best interest would be served by Mr. Copeland not being inside the Fulton County Jail. But that's just my opinion. So, Your Honor, I would ask that the court deny the motion for a mistrial at the very least, and if it goes any further, find that actions by people other than the state have led to us being where we are, because Mr. Copeland was at the point right before lunch of agreeing to testify. That is the reason we were ready to get started right before lunch. Because now he's been told he's going to be hammered by his attorney, I guess. He told him that, I guess, the state's going to hammer him. I don't even know what. But Ms. Hilton has gone over the questions that she has for Mr. Copeland. She has spoken with him about it. They have been speaking.
Okay, I'm going to stop that right there because it keeps buffering, and I think it's doing that sometimes when my VPN is trying to come on, or if it's telling me that I've used up most of the time and I need to take it off. I think that may have something to do with it, so it interferes with the Wi-Fi connection. Even though I bought Ethernet system to help stop that buffering, but it's doing it just too much, and time is too far spent. So we've been here a while. I want to go ahead and read this motion. You guys have gotten enough where you could see. Oh, I want to show y'all again the clip that I did a month ago. about her asking for this ex parte. Now, why didn't she ask for it when she was standing up there doing all that rambling, just repeating herself over and over and over again? Why didn't she ask for it in open court where everybody heard and understood it? She waited to this very end and did this.
And Your Honor, the state has a matter we need to take up expectations.
Okay. All right. Lieutenant Walker has been asked by defense counsels,
And Your Honor, the state has a matter we need to take up expectations.
okay.
And Your Honor, the state has a matter we need to take up expectations.
Okay.
And Your Honor, the state has a matter we need to take up expectations.
Okay.
And Your Honor,
That was probably hurting y'all ears. I'm sorry. I didn't know I didn't have the mic on. But as you can see, I did that a month ago when it happened. Okay, so in the Superior Court of Fulton County, state of Georgia, and this is Diamante Kendrick's supplement to Diamante Kendrick's motion for mistrial. Comes now Diamante Kendrick, petitioner, by and through his undersigned counsel, and brings the supplement to motion for mistrial showing as follows. Outside agitator is a term that delegitimizes internal dissent against the status quo. So anyone who speaks up against the status quo, whatever that is by definition an outsider. Professor Dylan C. Pennegrop, UC Berkeley. So that's what a professor wrote, and he quoted it. Judge Glanville making outrageous allegations against members of the defense team in the present case. Quote, but I think it does in some way outside agitators and everybody else who I think are trying to influence, unquote. The third ground argued in Kendrick's motion for mistrial is that Kendrick's due process rights were violated, relating to a 14th Amendment due process violation, relating in part to Chief Judge Glanville wrongly coercing Copeland to testify. Further evidence of the state and Judge Glanville's violation of Kendrick's due process rights has just come to light. Yesterday, after court, Kendrick received a rough transcript, Exhibit A, of an additional secret ex parte meeting with Judge Glanville held on Friday, June 7, 2024. The rough transcript was helpfully provided by the court to defense counsel. A reading of the rough transcript highlights that which has been obvious to all observers, except for Kendrick's counsel, for the past 19 months. Judge Glanville has been willfully biased and acting as a member of the prosecution team since the inception of this case. Kendrick's counsel takes no pleasure in alerting this honorable court to this situation, but client obligations require it. Due process requires a fair trial. It is not a fair trial when, in an ex parte meeting, Glanville, Love, and Hilton gossip like Yantas over 13 pages of transcript about attorneys Short, Melnick, and Steele. It is not a fair trial when, in an ex parte meeting, Glanville, Love, and Hilton assassinate the character of attorney Melnick and attack his integrity, alleging that he is not acting in the best interest of his client, Copeland. It is not a fair trial when, in an ex parte meeting, Glanville, Love, and Hilton attack attorney Bumpus for allegedly hugging Kendrick and stating that she is incapable of representing Copeland. It is not a fair trial when, in an ex parte meeting, Love lies to Glanville about an email she received from attorney Melnick. And she outright lied. It is not a fair trial when, in an ex parte meeting, Glanville starts talking about outside agitators, stating, "My comments today were predicated on there's a lot of stuff that's going on in the background, and it shouldn't have to do anything with you all's case. It really shouldn't, but I think it does in some way. Outside agitators." It is not a fair trial when, in an ex parte meeting, Glanville and Love have the following outrageous conversation. And so now we're going to go into the transcript, which I don't believe is all inclusive, just like the other one, because again, it makes no sense. And it's really funny, is if I recall, and I'll be reading this, and so we'll see if I'm right, they don't mention anything about the immunity that they granted that morning. This is what they say. "But I think it does in some way. Outside agitators," that's the court, Miss Love. "That too, the court. And everybody else who I think are trying to influence, Miss Love. This is absolutely happening." Rough draft, 11 of 12. It is not a fair trial when Glanville, Love, and Hilton have this further discussion. Miss Hilton: "There's a lot going on, Miss Love. There is a presence, yes. That is all I'll say." The court: "But I see it from just being in the courtroom and tracking." Wonder what does he mean by tracking? Because some of the looks he give to Mr. Steele, Mr. Short, some of those looks, if looks could unalive you, they would be gone. How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? This case is like an old house that the present honorable judge is tasked with renovating. Every time a piece of pasted up wallpaper is removed, more rot is found hidden underneath. No Herculean effort by the present court can fix the due process violations of the last judge. This house must be torn down. A mistrial should be declared and retrial barred due to prosecutorial and judicial misconduct that has goaded Kendrick into the present motion. Wherefore, Kendrick respectfully continues his request that this honorable court declare a mistrial based on at least due process violations of Kendrick's constitutional rights under the federal Constitution and the Constitution of the state of Georgia. And we must understand that it has to go under the Constitution of the state in which you live, because that's where your citizenry lies, within the state in which you live. What we not taught, that each state is a country of its own, and that's why each state has its own constitution. Each state does not have to bow to the laws of another state, but they can work in conjunction with one another. The merit that that state constitution has, whatever state it is. And then this is the 31st day of July 2024, respectfully submitted, Douglas S. Weinstein, and then he names the law firm. Now here is the actual ex-parte transcript that they want us to believe that started. Now it has 2:45 p.m. on it. I'm going to assume that 2:45 p.m. is the day that she handed this out, which was yesterday, I believe, because we know that they asked for the meeting at the end of trial, and I don't know exactly what time trial ended, but I believe it was after 2:45. I'm not sure, so I don't know what that 2:45 indicates. And so we're going to go with Miss Love. Judge, the reason that I specifically wanted to talk with you is that I have a concern about the representation being made of the representation of Mr. Copeland. I am concerned, and I am sort of not. I wanted to just bring it to the court's attention. Mr. Melnick has not conveyed to either Ms. Hilton, myself, or any member of the state any legitimate concern that he has regarding Kenneth Copeland testifying. What we have seen is physical interactions with persons besides Mr. Copeland, that would indicate that Mr. Copeland is not Mr. Melnick's primary priority. What we do know is that when the fact that he's willing and wanting to leave, number one, he left twice after the court ordered him to speak with his client. And it would seem to his actions convey that it is not Mr. Copeland's best interest that is his priority. What concern of that would it be of hers, in all honesty? That's how you know all of this is just for this trial is made for TV. It's like I've been saying all along. These people act like they're auditioning for a new show, the DAs of Fulton County, or the buffoonery of Fulton County criminal justice or injustice system. I don't know what they will title it. I'm not really good with titles, but something to that nature. Miss Hilton was out speaking with Mr. Copeland at Mr. Copeland's request at the time that I announced that Miss Hilton was calling Mr. Copeland. What I did not know is that she was trying to tell you to give us a minute because Mr. Copeland was feverishly, and I will let her speak as to how that went down, feverishly trying to get her in there to convey to her something that Mr. Melnick had just said to him that does not come from any of us, the court, which is Judge Biasville. What was that, Miss Hilton? And here is Miss Hilton. So let me just put the order of operation. I got up because Deputy Chief Long said, quote, he wants to talk to you. Come out right now, unquote. So when I went into the room, Melnick either came in or came outside. And what Mr. Copeland said, and I think that he wanted to get some autonomy, quote, I want to talk to you, unquote. He's like, quote, you, I've already talked to you, but I want to talk to her, unquote. And Mr. Melnick kept like blocking him being able to talk to me. Well, what attorney in their right mind would allow their client to talk to the prosecutors when you're sworn under oath or not sworn, and they represent you as your voice? See, one thing about courts is, as an individual human being with life and breathing, you can't speak to the court because you are considered a corpse. So everything has to be done in writing through what is known as your straw person, all cap name. So you can't just go in there and speak unless you come in under pro se, which is a form of their jurisdiction representation of yourself, or sui juris, which is you're coming in your own personal being. It's called sui juris, is what it's called. These Latin terms that they use in law, sometimes can mess up the way we, pronounce them. So, let's keep going. So eventually, I was like, quote, well, clearly you want to talk to him, so I'll step out and you can come in, unquote. Mr. Melnick spoke to him, and I think he was trying to eat up time because he knew that you were coming out. They can always think of the operation of other people's minds, and this man goes along with it. How can that be? And this is a real, supposedly, a fair tribunal of equity and fairness, honesty and integrity, but he can take their word on what they think they know when everything in that room is based on proving what you know. Makes no sense. So by the time I got back in there and he started to talk, that is when everyone said, quote, come on, the judge is waiting, unquote. And that's why he stormed in angry. Miss Love, he being Mr. Copeland, Miss Hilton, because I think he was trying to convey to me some concerns he had. And so I was trying to have that conversation because Mr. Copeland and I have been having really good conversation since Friday. Like very, very good conversations. Why is all of this important for them to say? And Miss Love had just said that in the courtroom. As I told y'all to listen to her and what she was saying. If you actually did hear her, you know that all of this is just repetitive. And as they call it, cumulative. And they're just saying the same thing over. This is to cover your ass part, in my opinion. Miss Hilton, just not even about the facts of the case, but just life experiences. So I think I was building a rapport with him such that he thought I lied to him. So I was trying to explain to him, Miss Love, and by that same means today, Miss Hilton, today about what was going to happen, Miss Love, because of what someone conveyed to him. Miss Hilton, we believe that something was being conveyed. What happened is Mr. Copeland was walking back into the courtroom. Mr. Melnick and Julie would have to, Miss Lansequit would have to confirm this. But he said, quote, they are going to hammer you, unquote. And that made me ask Miss Love, quote, did you say something about hammering him, unquote. And I don't know who. Then Miss Love says, nobody did. Nobody did. She said that unequivocally, like she knows nobody did. The court, it doesn't make sense. You would say that to him, Miss Love. We never said that, the court. But anyways, okay, Miss Hilton. So whatever that communication was, that's when he stormed in and got angry. And the result I got was what he gave when he started. So at this point, I'm very concerned, Miss Love. He, meaning Mr. Copeland, stormed in and got angry. Miss Hilton. The timing of everything is very ironic. We laid it out on the record earlier about what happened, and I don't believe that Mr. Copeland's best interest is being served at this moment, given that, Mr. Melnick was willing to take a vacation and let him languish in jail. And that is not. We have communicated that we never wanted Mr. Copeland to go to jail. We don't want him in custody. We don't want any of that to occur. And so they don't want him and all the criminality that they say that he possessed, but they want an attorney who's representing a client who hasn't never been to jail to go to jail for contempt. Makes no sense. Miss Love. And Mr. Melnick has not spoken. He has not relayed what we did get during the break was an email from Mr. Melnick. I don't know if he had to have been blind copying someone else. The only two people I could see on the email was Miss Hilton and myself, but he referred to me in the third person and said, these are the communications between myself and Miss Love. So I asked Mr. Melnick, quote, whose interests are you concerned about, your clients or Mr. Steele's and Mr. Short's? And unquote. Because prior to, and this is not the first time Mr. Copeland has said, quote, he doesn't represent me, unquote. This is not the first time Mr. Melnick has, and let me be real clear, when he spoke of what was happening before, him representing Mr. Copeland and da-da-da-da-da-da-da, he told me that he didn't represent Mr. Copeland. He told me. But when she was in court, she think that's what he said. But here she's unequivocally saying that he told her personally. The court, Mr. Melnick told you? Miss Love, yes, Mr. Melnick told me previously that he wasn't representing him. But Mr. Melnick stood in open court and the judge heard him say, Your Honor, I have the emails when we last communicated in 2023. So all of this is just charades. The court, you would not speak to an unrepresented party. I know you know enough of the rules to know that if you thought or intimated that somebody was represented by counsel, you would go ahead and let them contact that lawyer. Miss Hilton, or Mr. Copeland would have said, because I don't know as a witness, because he's not charged, if we would have had to. Okay. And Miss Love said, right. Miss Hilton, because he's not charged. So they think because he's not charged, the fact that he has an attorney, and they want to speak to him about a case that they had talked to him about, or his attorney about just a year prior, they don't think they have to say anything to his attorney about wanting to bring him in now under subpoena to testify. The court, I don't think you have to because there's no pending charges. But if he told you, quote, I got a lawyer, I don't want to talk to you. Miss Love, we would have left the court, because people counsel that they have under retainer or something else, or they say, quote, hey, I got a lawyer that I use for everything, and I want to talk to him. I'm not comfortable talking to you unless my lawyer is present, unquote. Ms. Hilton, we have done that with a number of our witnesses here, so this would have been no different. And what is she referring to they've done with a number of their witnesses? Because they impeach all of their witnesses except for the law enforcement officers that all got caught lying on the stand. So what does she mean by that statement? Miss Love, exactly. And we would have, I'm sorry, I don't mean to cut you off, Miss Hilton. No, go ahead. That was it, Miss Love. We actually communicate, especially when either they are incarcerated or subject to having their sentence revoked as a result of their testimony because they pled guilty here. We only reach out to them through their attorney because we want the attorney to speak to them, and for that to be because that's the best way, in our opinion, to get a rapport that elicits truthful testimony. So in this particular instance, there was not that, number one, there was not that communication made by Mr. Copeland that there was ever a need for that. And two, there was not a need for us to be concerned about it because he doesn't have charges. Miss Hilton explained to him at length that whatever happened that he did in 2015, which is all we're going to be talking to him about, the statute of limitations has run. He didn't do the murder. We know that. So I don't want to get into the facts of anything. What I'm trying to get at is the fact that Mr. Copeland, I believe Mr. Melnick has inserted himself in a way that jeopardized the best interests of our witness. I believe that in conveying to the court that Miss Bumpus is going to stand in his stead. Miss Bumpus she was, what is the word I'm looking for? The sheriff had to speak to her because she was in the courtroom trying to hug Jeffrey Williams. Miss Hilton, no, she hugged Diamante Kendrick. Miss Love, I'm sorry. Miss Hilton, in fact, she hugged Diamante Kendrick and hugged Mr. Williams. And that's how Captain Kendall saw her. And Captain Kendall had her taken out. Miss Love, she expressed dismay and concern in challenging her right to go interact in that manner with the defendants. So our concern is that it is not Mr. Copeland's best interests that are being represented. And that not only is that the case with respect to Mr. Copeland, who we have, with Mr. Copeland, who we have no interest in prosecuting, but there is a tampering of sorts going on in this person inserting himself where Mr. Copeland was reaching out to speak to Miss Hilton, and that communication is being blocked by someone Mr. Copeland didn't reach out to. So she's saying because Mr. Copeland didn't talk to his lawyer, he's blocking the communication from him being able to talk to Miss Hilton. This is all so very bogus because the court asked who was going to be standing in Mr. Melnick's stead, and that's why they knew it was Caleb Bumpus, because he said it in open court. So they went to work then, and that's why at the end of the day, Miss Love asked for the ex-parte meeting. And like I said, one that Friday, because nothing made sense based on what they were saying in the transcript on Monday, unless they had had previous conversations. But I believe the Ex-Parte conversation dates back to the 6th of June, when they received the email from Mr. Melnick saying that his client was represented by him and that he was going to plead the fifth. I think they started with the judge then. They'll never make me believe they didn't, because how did they have the document ready for Friday morning before he was due to testify to say that it's already been done? It makes no sense if you're just thinking with a human brain. An everyday lay person, a reasonable person, you don't have to know law to have common sense. All you have to do is have experienced something in this life. Miss Love. She expressed, okay, I read that. So our concern is that it is not Mr. Copeland's best interest that be represented. And that not only is that the case with respect to Mr. Copeland, who we have no interest in prosecuting, I read this, but there is a tampering of sorts going on in this person's inserting himself where Mr. Copeland has, I read that, where Mr. Copeland has been reaching out to speak to Miss Hilton, and that communication is being blocked by someone Mr. Copeland didn't reach out to. You notice no one said, quote, Mr. Copeland called me, unquote. He never said, when we put on the record, when Miss Hilton said, quote, the way I understand it, Mr. Melnick reached out to Mr. Copeland, unquote. Because the first time we heard an assertion like, quote, oh, he's going to plead the fifth, unquote, is when Mr. Melnick sent an email to Miss Hilton and myself and had copied on it Mr. Steele and Mr. Short last night. The court, why would he have done that, given Miss Hilton? And that's the state's concern, Miss Love. That's the point. The court. Why wouldn't he have done that when they are the defense? And he's putting everybody on notice. Why wouldn't he have done that? What would be wrong with that? The court. But here's the challenge. The challenge is you have privileged communications. And unless you've got him being the client, disclosing to a third party that wouldn't be subject to the privilege, that is the only way you are going to, Miss Love. I don't disagree with that at all. But if Mr. Melnick, and the thing that got me the most is Mr. Melnick is not looking at Mr. Copeland saying, quote, Mr. Copeland, I want you to stay out of jail, and I will be here with you. And if they ask you anything that touches upon something that you and I talked about, I will stand up and assert your right, unquote. He didn't do that. Well, the question would be to me, why would he have to do that if you all now has given him immunity, and according to you all, y'all not going to ask him anything that would precipitate you guys going ahead and coming up with new charges against him for something independently based on what he said. You would not do it on what he said because that's use immunity. But if what he said, if it can take you down a level that you can get a new charge, then that's not covered under the use immunity. And I did several videos about the different 3 types of immunity that are given. So you might want to check those out. Let's see here. What he did was he looked over at 2 people and said, like, quote, I did what I could, unquote. Shrugged his shoulders, held up the palms of his hands like this, as to say, quote, I tried. Quote, first, she said what he said with his back being to her. So if she heard him, then everybody in the courtroom should have heard him. Then she said he shrugged his shoulders. If she saw him, everybody in the courtroom should have saw him. And especially the judge, who says he sits from a vantage point that he sees everything that's going on in the courtroom. Certainly, if he witnessed that, just as angry as he got at Mr. Bott for not telling him, that he should have been angry with himself for not acting upon what his eyes surely saw. Because if Miss Love saw that, everybody in that courtroom saw that. Unfortunately, that did not. Well, fortunately, that did not happen. And unfortunately, she's lying, which has become a norm for her. For Miss Love to pretend she has so much care for Mr. Copeland is unimaginable, because she's the same person that prosecuted a special needs young man who was unalived while serving time in Rice Street, one of the worst county jails, it sounds like, in all of the states put together. She said they were pretending and nothing was really wrong with that young man. But she wants us to believe that she has all of this thought and care for a young man that has said he is a criminal and he does lie about everything, and he's only told the truth today out of all of his telling. Now, we know everything he says has not been a lie. Matter of fact, when you listen to his story as a mother and a woman, you should be able to appreciate his story and his pain, not his crime. No, I'm not saying that. I'm saying the things that caused him to make the decisions that he made based upon the knowledge that he had. And a lot of us call it giving people excuses and giving people passes. No, people are just human, and everybody loves to remind you how imperfect we are until it applies to someone other than them. The imperfection always comes when they're excusing their behavior or the behavior of someone they love. But when it comes to others, there are no excuses and certainly no second chances. Well, maybe you can do that and you have that right. I don't do that, and I don't think like that, and I don't live like that. And perhaps that's why I end up in a lot of the situations I do, because I believe in second chances, and I believe in change. And I believe in things not happening the way I planned it to be, because that's how it is sometimes. So, she said, there's no reason he would be looking to the right to counsel for the defense like, I tried, quote unquote, after Mr. Copeland said he was going to testify. That doesn't make sense. And giving props to infamous Sylvia, she had shown a video of actually Mr. Melnick standing up at the podium during this time period that this lady, Miss Love, said that he did the shoulder shrug and looked over to the right. And if you ever get a chance to see her video, you will see none of that happened. The man never looked over that way. So this lady can infer and insinuate and give all of these innuendos, and the judge actually takes it as the gospel and makes his decisions based on this woman's lying and babbling. I've never seen nothing like it in my life. The court. Well, there's a lot of innuendo that have asserted themselves, quote, they, unquote, being some of the defense counsel, have inserted themselves in this particular process. And that's what, Miss Love, my concern is Mr. Melnick's insertion of himself. I don't get that insertion and he's the man's attorney. I don't get that part. The court. What are you asking me to do? What are you asking me to do? And what do you think I can do? Miss Love, That is the exercise. That is the homework for tonight. I wanted to let the court know that that is what we're looking into right now, because there is a remedy, because I have faith in our law. Boy, this lady's pointed on thick. I love this thing, and I know there is a remedy, because this can never have been the first time this happened. It has been addressed. I just have to find it. And they have a problem finding case law. And when she does find case law, she finds case law that's not applicable to this case or any situation thereof. So her finding some case law on some stuff that they're just conjuring up, I just know she's not going to be able to do that. And I don't know any that she was able to do. But I didn't want to be looking for something and not let the court know what I'm looking for. So that you are caught off guard when Monday morning or Saturday night or Saturday afternoon we find it and send it to you. So again, like I said, with just these conversations here, no reasonable person would believe that what precipitated all of this behavior was Mr. Melnick sending an email to to Hilton and Love, stating that he represents Copeland and he plans on pleading the fifth. That alone is what started all of this. When they started contacting the judge, they didn't wait. They started contacting him when they got that email. That's what they did. Now they can tell it to somebody else another way. And I don't never have to see it on video to understand how logic works. And what they're saying is illogical, doesn't make sense. And if Judge Judy's favorite line, and mine too, if it doesn't make sense, it's not true. And you don't have to, well, you can test the theory all you want, but if it doesn't make sense, it's not true. The court, okay, Miss Love. So thank you for allowing us to, the audience. No. Thank you for allowing us to audience with the court. I just wanted to make certain that we did it properly. How is this proper? And we had everything on record. It is our witness. We have conveyed to him that he is shielded from prosecution for anything that he talks about on the stand and any use of that. And the thing is that we won't ask him that. But this is what he said. Quote, y'all might not be, they might ask me about some things that I have to assert my right on. That man ain't said nothing about no assert his right on. He don't even use the word assert. I'm not saying he doesn't know the word assert. I say he doesn't use it in his everyday vernacular. From everything that we've heard of him, we know he's not running around asserting in a sentence nothing or in a conversation. On that would be a question by question basis. What he is being influenced to do, we believe, by Mr. Melnick is, and it's through Mr. Melnick because, as you saw, Kenneth Copeland said, quote, I will testify, unquote. Mr. Melnick even after that said he's asserting his fifth. I'm going to go talk to him. Logically, one would think that as long as Mr. Melnick's concerns about Kenneth Copeland's freedom, legal freedom, and his exposure, as long as those were addressed, Mr. Melnick should be saying, quote, I am here with you. If there is something that I know will put you in jeopardy, I will stand up and stop you. But right now, I would rather you stay out of jail, unquote. Instead, you get Mr. Copeland, and you can see through his body language. He gets there in court, and he's smiling as if making a show of being taken into custody after this. And the man don't want to be in jail. He said it. Didn't he say he didn't want to be in jail? Miss Hilton, that's his biggest fear, Miss Love. That's his biggest fear. And now he's in jail after Mr. Melnick asserted himself in this process. So we have to go figure it out. I'm not just laying it on your lap saying, quote, go fix it, go fix this, unquote. I'm just bringing this to the court's attention. This is a grave concern. Miss Hilton, she's about to lose her mind because her biggest concern is that Mr. Melnick is actively harming a human being. And that's what she's maddest about. I'm mad because it is stopping our trial. And it's wrong. And that is not how the law is supposed to work. Hush now. So we have two big old grave concerns that we are working to remedy right now. The court. Okay. Well, like I said, I think that you brought your concerns to me. You know, without more, I don't know what else I can kind of do in terms of that. My comments today were predicated on there's a lot of stuff that's going on in the background, and it shouldn't have to do anything with you all's case. It really shouldn't. But I think it does in some way outside agitators. Miss Love, that too, the court, and everybody else who I think are trying to influence. Miss Love, that is absolutely happening. Miss Hilton, there's a lot going on, Miss Love. There is a presence, yes, yes. That is all I'll say. The court. I mean, but I see it from just being in the courtroom and tracking. But okay, if you find anything, we'll see where Monday leads us. And like I said, since we now know he's going to potentially invoke, we'll see what his pleasure is. And Miss Love, I mean, just the idea of someone sitting in jail throughout this trial. But how can that woman say that and they're the ones who asked for them not to give those guys bond? And Jeffrey Williams doesn't even have a felony, but she want to pretend it's the title. So now if you're the shooter, the stepper, the robber, the jacker, if you're all of that, that's cool. We don't want you in jail, period. But if you're the person that they say, just give the orders, you're the most dangerous person in the world, but these people ought to stop. You know, they're looking at too much TV. And that's probably why their case is not together, because they're not putting time and work on a case. I tell you, as a pro se litigant, I prepared much better than these people. I don't know what they're doing, but they are not doing the people of Fulton County a service. Again, what my idea of what they're doing is exhausting all of the ORCA money that has to be exhausted by the end of this year. And all that is not spent has to go back. So that's the only thing I can see that these people are doing, to be real honest. But that's just one woman's opinion. Miss Love, I just read that line about the idea of somebody being in jail throughout this trial. But if that's what he's being counseled to do, and that's what he does, that's just wrong. It's wrong because a member of the bar is, in my mind, creating that circumstance, you know? He's going to do what the person he trusts to have his best interest at heart tells him to do. And that person, he doesn't have to tell us what he's concerned about. So she's saying and that person, and they, maybe they're leaving out all of these names and stuff, but it's very hard to believe with the brazen conversation that they seem to be having with one another. But it's also like cherry picked as well. Words are placed in perfect place for it to be what it is. And can just sit there. And when he sees the train coming, and they love to use the metaphor train, they all use the train. Wonder why. Stand up and say stop. But he's got a vacation to go on, so he can't be here. So Miss Bumpus is going to be here. Miss Bumpus hugging Mr. Kendrick and Mr. Williams is going to be here representing the interest of Kenneth Copeland, who is supposed to testify against Mr. Kendrick and Mr. Williams. That is where we are. That doesn't pass a smell test. The court. All right. Okay. Miss Love, thank you. And that's supposed to be, and he certified and sent this, that's supposed to be the transcript from the meeting that Friday. Well, what happened when they did the emailing to one another and when they talked that Saturday and that Sunday before they got there that Monday morning? Those are the kind of questions that I have. But I just wanted to make sure that I came on tonight and give my take on what I see happening. I cannot see how this judge cannot do a mistrial with prejudice. But of course, stranger things have happened. When you're an Asiatic African, it doesn't matter how much money, fiat, gold, silver, that you honestly have in your possession. What the intentions are, they are to take all of your possessions and then take your body into custody. So it's unfortunate, but again, if anybody that's listening is interested in any of the information that I have to help you start on your path of research, I am willing to send it to you. All you have to do is send me an email, and then you do what you can with the information. We can't worry about what people say, think, or feel, or even what people do or don't do. We're only responsible for ourselves, our thoughts, and how we treat others. And if you are true to yourself, I just truly believe you'll be true to everybody you meet. And if you love yourself, I believe you can show human compassion and you can communicate with others. Doesn't mean that you don't have flaws, because I do. And I know that all do, as being human. But it just means that you can be your authentic self and give a person what you have to give, and that's who you are and nobody else. You don't have to pretend to be nobody else or act like anybody else, although we do tend to pick up other people's idioms and the things that they do, and that's okay too. That comes again from being human. But on that note, I want to thank you both for staying with me. It's an honor to have people to stay with me because, like I said, I'm going to do this thing, whether it's me and the camera and the live feed, or it's one or two people in here with me. I appreciate you for staying or for coming in and being with me to the end. If you didn't get to see the whole video, I hope you go back and look at the beginning. Basically, I'm just giving my take on how this started, and nobody really is honing in on the email that came on the 6th caused the effect of the immunity on the 7th in the morning that nobody knew anything about but the judge and the prosecutors. And Copeland and his attorney found out, Melnick found out when they showed up that morning. And that's when, things really hit the fan. And then the way the judge explained what he explained, I didn't hear any different from the transcript on the 10th than what he said in open court. So the necessity for them to have that meeting, it was not in his interest and his comprehension of immunity. It was to coerce, to intimidate, and to do exactly what they did, get him to testify. And the reason they keep stressing he's not under any charges and they don't understand is beyond me. But I hope that all of the progress that he's making, if he's actually making progress, I hope that it continues. I hope that he continue to be able to make money, because then he can take care of himself without having to do some of the things that he's done. I hope he doesn't get too far enamored with success, as we call it here on these public forums. You know, when you get people that become your subscribers, your followers, your fans, your whatever you want to call them, and they make you feel larger than life, and then the money starts flooding in, and then you start thinking, hopefully he has principles, and he sounds like he does. It sounds like his mom gave him a foundation, and he loved her with his whole heart. So that would take him a long way, and maybe that's how he survived, because everything that it sounds like these young men did was survived their environment. Doesn't mean they didn't have loving parents at home. It does not mean they were not taught right from wrong. When you live in a certain environment, you have to survive outside of your parents' home. And if you're not wise and quick in your thoughts and actions, you can become a casualty of your own neighborhood. So with that being said, as you all know, that I believe the children are our future. And so I'm going to get ready to leave the Tiger's Den. Before I go, I'm going to put in the chat this. If anybody is interested in filing a complaint, then I'm going to put that link into the chat, because we all have a right to petition our government. And that's one of the problems we as a people, we don't do. We don't come together, and we don't have to be in the same conversation. We don't have to be in the same place. All we need is the same action. We don't come together as a people and petition our government for change. A lot of people think we have to take up arms. I promise you, we don't have the weaponry that will give us longevity, but you have to do what you feel you need to do. I would suggest that you read and learn. That's what I would suggest, but you do whatever you're moved to do as an individual. And on that note, I'm going to say I'm leaving the Tiger's Den. Good night. I believe the children are our future. Teach them well and let them lead the way. Show them all the beauty they possess inside. Give them a sense of pride to make it easier. Let the children's laughter remind us who we used to be. Everybody's searching for a hero. People need someone to look up to. I never found anyone to fulfill my needs. A lonely place to be. So I learned to depend on me. I decided long ago never to walk in anyone's shadow. If I failed, if I succeed, at least I'll live as I believe. No matter what they take from me, they can't take away my dignity, because the greatest love of all is happening to me. I found the greatest love of all inside of me. The greatest love of all is easy to achieve. Learning to love yourself is the greatest love of all. And if by chance that special place that you've been dreaming of takes you to a lonely place, find yourself in love.